Good morning, everybody. Happy Super Friday. Welcome to TCF Live. My name is Dan Soul. I will be your guide through Courtlandia for the next 3 hours today. Not 4, but 3. Started in Michigan, Judge Anzalone.
22565FH and 26-2, and 2, well, no, that's another one. 26-22568FH. I have Brian Fry appearing on behalf of the defendant. I have Alexander Bayanetto appearing on behalf of the people. Tom Moore is appearing via Zoom from the Michigan Department of Corrections. Mr. Hansen-Nieto and his attorney are in person, as is Mr. Bayanetto. So, Mr. Fry, you did receive a copy of the pre-sentence report.
Yeah, I did receive it yesterday, Your Honor. I was able to get to the jail yesterday and meet with my client and discuss it with him.
All right. So, Mr. Hansen-Nieto, you've had an opportunity to read and review the pre-sentence report.
Yeah.
Okay. And do you want them next to you or seated, or what would you prefer?
Yeah.
Okay.
I want to know if this is the same here.
Yeah.
What is it? Oh.
So, Mr. Hansen-Nieto, you've had a chance to read it, and Mr. Fry came to visit you yesterday. Is that correct?
Yeah, sure.
And you were able to ask him any questions you had and discuss it with them?
Yeah,
Do you have any more questions from Mr. Fry?
no,
Are you satisfied with Mr. Fry as your attorney and the advice that he's given you?
yes,
Mr. Fry, do you wish to explain or challenge the accuracy or relevancy of any information in the pre-sentence report?
No, Your Honor.
All right. Does, Mr. Bayanetto,
no, you're right.
does the pre-sentence report disclose any prior convictions in which there exists any known constitutional defect? He has 25 prior misdemeanors and 14 prior felonies. Mr. Fry?
I don't believe so, Your Honor.
Mr. Bayanetto?
No,
All right, so probation department has calculated the minimum sentencing guidelines to be on file number 26-22505FH, retail fraud first degree, to be 12 to 24 months. Do you agree with that computation of guidelines?
Yes, Your Honor.
All right.
yes,
And on file number 26-22565FH, on the assault with a dangerous weapon, they calculated the guidelines to be 14 to 29 months. Do you agree with that calculation of guidelines, Mr. Fry?
No, Your Honor.
Okay, so let me back up here. All right, and are you disputing any of the PRVs?
No, Your Honor.
Are you disputing any of the OVs?
Yes, Your Honor. I believe OV12, which is scored at 5, for 2 other criminal acts should be scored at 1, which for 1 other criminal act, the other criminal act in that case would be the retail fraud. But the original charge, unarmed robbery, and the felony assault that he actually pled to are the same act. It was for punching somebody on the way out. So there's really 1 other act. So that should be scored 1 point instead of 5.
Mr. Bayanetto?
I'll stipulate that, Your Honor.
All right, so Mr. Moore, the people have stipulated, so OV12 will be scored at 0. Are there any other OVs you're objecting to?
I believe it should be scored at 1, Your Honor.
Oh, I'm sorry, 1.
Yeah,
Okay,
and we wouldn't object to any other OVs.
all right, so that means the OVs would be 31. Does that change the guidelines?
The guidelines would then be 12 to 24 months, Your Honor.
Do you agree with that, Mr. Bayanetto?
Yes, sir.
All right, on file number 26-22568FH, retail fraud first degree, the guidelines were scored at 12 to 24 months. Do you agree with that computation of guidelines?
Yes, Your Honor.
And Mr. Bayanetto?
Yes, sir.
All right, Mr. Bayanetto, is there anything you would like to say on behalf of the people before the court passes sentence?
Your Honor, I was trying to find Mr. Nieto Hansen's profile on Otis. I had looked at this at that prior to, I think prior to the case even being bound over to circuit court. My recollection of that is Mr. Nieto Hansen had only been released from the supervision of MDOC, whether that was parole, probation, I can't remember. But there was only a period of 1 or 2 days before Mr. Nieto Hansen began engaging in felonious criminal acts again. He was arrested on, I think, 3 retail fraud firsts, released on a PR bond at the time of exam. The case was then bound over up here when the unarmed robbery happened. The court has Mr. Nieto Hansen's record in front of it. I understand there may be some mitigating circumstances, but I think the recommendation from Mr. Moore to have a period of 2 to 4 years in MDOC is appropriate, and I would ask that the court follow that recommendation at this time.
All right, Mr. Fry, is there anything you'd like to say on behalf of Mr. Needle Hansen?
Yes, Your Honor. So my client has faces some significant challenges, I think, that are outlined in the PSI with his criminal history and his significant mental health concerns and his significant substance abuse issues. Housing, and the list goes on. You know, he was homeless. So he had a lot of things going against him. He made some poor choices in this case. He has fully taken responsibility for them here, and he's explained, you know, what he was dealing with is he had been incarcerated for quite a long time, and he got out. He had nowhere to go. He's homeless on the street. He, you know, was stealing food from, you know, grocery stores and some clothes and some other things to provide for himself and to obtain drugs. So he, we don't dispute he was making poor choices. We don't dispute that there should be some consequences for his actions. But we would ask that the court consider, you know, not sending him to prison in this case. We have guidelines in all of cases of 12 to 24 months, which would support a jail term. My client has been doing well in the jail. The court can see from, you know, his clothes color today that he's a trustee over there. He's doing well and following the rules. If he can be put on regular probation, the court has more control over fashioning, you know, some terms that can support him in the community, which can include, you know, drug use monitoring and, you know, help him with services to help ensure that he can be a law-abiding citizen when he gets out. He had expressed, you know, at the time of his plea that, you know, he's 60 years old now, and if he continues down this path, he's gonna die. So he certainly recognized he needs to make some changes in his life. He needs some mental health services and some substance use services to help him do that. And I think probation would most support him being able to do that. So we would ask for you know, a jail term with probation versus prison, which would then result in parole. Thank you.
Mr. Needle Hansen, is there anything you'd like to say in your own behalf?
Oh, yeah, I just, like I said, it was, I'm content with, pleased with the plea agreement they gave me. They blessed me. You know, I was homeless and doing wrong, and I'm just trying to get hoping I get a year and then a long-term rehab that Ms. Fitzgerald had set me up with. It's in Bear River Health. It's called Bear River Health. It's 4.5 hours away. You know, like, that's what I'm presenting. And that's it, you know.
Miss Fitzgerald's from the jail?
Yeah.
Okay.
Now, she gave me the paperwork for Bear River.
Okay. Have you ever been to rehab before?
I never had a chance to go, the program is, the reason why it's so good is because it's they help. It's not just, you got to do it, whether it's 60 or 90 days first, but it's a transitional. They help you get a job and pay rent at that place.
Mr. Nieto Hansen, you've been on probation, violated probation many times, ending up with a prison term. What do you think is different here today?
Oh, this is my age factor from 60 now, and I just need to slow down on what life I have left. I want to die a sober man, and I want this help more than anything else. You know, we pay my debt, and pay my fines off, and do a year, and do the year first, and pay my fines off, and seek this help that Fitzgerald sent me the application for. It was the paperwork of how it's structured. You know, she gave me that. It was about 6 pages long. The schedule shows you the schedule on the meetings, and the group meetings, the private meetings, the church, and the meetings, the schedule of the everyday meetings there. Yeah, I got the paperwork at the jail.
Okay, Mr. Fry, we've used Bear River before through our recovery court program. That's like a 4 to 6 month program, is it not?
I'm not familiar with that program here.
Mr. Moore, do you have any information?
As far as I was aware that he's not eligible for that program. If you want to take take a minute, I'll make a phone call, but that was my understanding.
I mean, we can verify that, and I'll consider it, but I want to know if he's available for it before I make a decision. So, Mr. Moore, are you able to reach someone at the jail?
Yes.
Okay.
Yes.
All right. So have a seat, sir.
It's TCF Live on a Super Friday. Good morning once again, everybody. My name is Dan. It is good to have you here. Programming note, we're doing 3 hours today, not 4. I've got a couple meetings I have to take today. Lindsay, 11 months with us. Thank you so much for all of your support. Your enthusiasm for what we do here and your participation in it and everything never goes unnoticed. It's very much appreciated. So thank you. Just would not be the same without you around here. So appreciate you.
You can sit down, Mr. Fry.
So we're
making me nervous.
We're a couple minutes in the way back machine, so I'm going to try to bump this forward past this little pause here.
The sheriff's in Detroit.
He requested paperwork, but there has been no effort to attempt to put him in a program or tell him that he could be eligible for it. Probably there could be a issue with that place because of the registration. Doesn't mean that there's not another location or something, but as far as that program itself, most likely not, but he has not been pre-approved for anything.
All right, Mr. Fry.
So, I have nothing further in.
Okay, go ahead and stand next to me, please.
I have, forgot to mention to you, Your Honor, it's been so long ago, in 2014, I believe I had a parole with Anna Wilkerson, and she did send me to I went to a program in Lansing for 30 days, transferred to a program called the Share House in Detroit, Michigan for 90 days, and I was on alcohol monitor. I like to see. So I know they will hold my registration against me at the Share House in Detroit. And I would transfer there, and they had transitional housing too to live in. I would get an apartment and a job. So I know that for a fact. That could be set up. So it has to be a year in the jail. I don't come out, like I said, I'm not tethered alcohol. That's the only thing that saves me. I'm conscious about not drinking, and I stay sober. I succeed in that. That's the only good thing I could tell you about myself, is that once they put that bracelet on me, I do it for 2 years if I had to, but I come out successful.
Mr. Hansen-Nieto. Nieto Hansen. Hansen-Nieto. Okay. You know, we can adjourn this a week to see if there's any program available for him. But, you know, with his sex offender registration, that does limit him, and it would have to be a long-term program. But if he violated, he would go to prison. So, Mr. Fry, you want to set this out a week or so?
Yeah.
If there's a program available that's long-term, I'll consider it.
Okay.
Mr. Coast may be able to work with you, Mr. Fry, as well as Mr. Moore. Miss Adams, when can I set this out, please?
How far do you think, Judge?
A week as soon as possible, or two.
Yeah, we could do April 24th at 8:15.
Are you available, Mr. Bando?
So. I am, Richard.
You know, Mr. Hansen-Nieto, you've been to programming, you've been given services. So, you know, I'll give you one more chance if we can find a program for you, but,
All right, yeah.
all right, thank you.
Fair enough. Thank you.
Thank you. That's right, thank you. We'll see you back on that day. Okay, just pop up. Oh, there you are. All right, let me call the jail for your guy.
Yeah, I'll have to talk to him on Zoom if that's okay.
Oh, that's fine. Staying for this one, Mr. Bando?
No, I am interested.
All right, we'll keep an eye on Judge Anzalone's court, but while they're racking up other contestants, let's stay in Michigan, but we'll go up to Missaukee County and Jason Elmore.
For the 28th Circuit Court here in Missaukee County. And this morning, we are going to begin today by taking up the first case of People of the State of Michigan versus Andrea Bloss. File number here is 25-3607FH. Appearances, please.
Thank you, Your Honor. David Denhout on behalf of the people. May it please the court, Robert Champion appearing on behalf of Ms. Bloss.
Ms. Bloss joins us this morning via Zoom from someplace out there in the world. Ms. Bloss, can you see and hear the court?
Yes, sir.
Thank you very much. Also here before the court this morning is Ms. Laura Odell. She is an agent with the Michigan Department of Corrections, serving as the probation officer on this case. The defendant was sentenced back on December 1st of 2025 on a conviction of possession of a controlled substance, looks like heroin or cocaine, less than 25 grams. She was sentenced to a period of 12 months of supervision pursuant to MCL 771.1. And we are here today for arraignment on some alleged bond violations. One moment. All right, Ms. Bloss, I need to tell you what the allegations are, what your rights are, and your possible consequences. Now, first of all, I'll note that this is a request and a warrant for probation violations, which I signed back on March 19th, 2000 and, well, it says 25, but clearly that was my typo and it should have been 26. Ms. Bloss, there are 5 allegations. Count 1 alleges that you violated condition 2.8, which requires that you complete outpatient or residential treatment when referred by your field agent, and more specifically, that you had failed at that time to complete outpatient treatment after being referred by your supervising agent. Count 2 is an allegation that you violated condition 4.19, which requires that you have no contact with Department of Correction inmates without permission. And more specifically, it alleges that you have had ongoing contact with Anthony Prentice, who is an inmate with the Department of Corrections. Count 3 alleges a violation of condition 4.2. That requires that you must comply with the written or verbal orders of your field agent. And more specifically for count 3, it's alleged that you failed to comply with the verbal orders of your supervising agent by having continued contact with Thurston Kenonen, Keinonen. Count 4 alleges a violation of condition 4.25, which requires that you report any arrest, police contact, change of residence, or loss of employment to the supervising agent within 24 hours. And more specifically, it's alleged you failed to report a change of residence and change of employment status to your agent. And count 5 alleges that you violated condition 4.22 again. That requires that you comply with all written or verbal orders of your field agent. And more specifically, that you failed to report as instructed and scheduled on March 18th of 2026. You have the right to challenge these 5 allegations at a contested hearing. At that hearing, the prosecutor would have the burden of proof by a preponderance of the evidence. At that hearing, you'd have the right to review any of the evidence presented against you, question or cross-examine any of the witnesses against you, as well as have the right to present witnesses, evidence, or testimony, as well as the right to remain silent and not have that silence used against you. You also have the right to be represented by an attorney at that hearing and all subsequent proceedings. Now, we know obviously here that we've got Mr. Champion who is going to continue to represent you. Is that right?
That is correct, Your Honor.
Bingo.
She is on delayed sentence.
All right, that's because of the delayed sentencing. Had the sentencing been final, I'd have to go over possible requests and appointments of further counsel. Now, if you're found to be in violation of these terms or conditions, number 1, the court could revoke your delay of sentence, making the charge and conviction permanent. And then 2, the court would re-sentence you on your original offense. Again, a charge of possession of a narcotic or cocaine is a felony punishable by up to 4 years and or up to $25,000. Now, these appear to be the first set of alleged probation violations. Am I correct, Ms. Odell?
It is, Your Honor.
And I keep saying probation violations. Technically, it's not probation, it's a delay of sentence, but they effectively are the same thing. But anyways, the court could sentence you again up to 4 years. Now, there are 5 technical violations. When they are technical violations, the court is limited to a sliding scale. For 1 technical, the court can give you up to 15 days. If there are 2 technicals, the court can give you up to 30 days. If there are 3 technicals, the court can give you up to 45 days. However, if you're found guilty of 4 or more, then the court would no longer be limited by that sliding scale, would only be limited by the amount allowed under the law. Yes, sir?
I apologize, Your Honor. She was sentenced as a second offender, which does have an impact on the potential sentence. Your Honor.
All right, thank you very much, and I appreciate that. I told you that the maximum punishment was up to 4 years. However, you were convicted as a second sub. Let's take a look here. It's the judgment of sentence.
Habitual second, Your Honor.
Habitual, okay, there, all right, thank you. Habitual offender second means the maximum punishment could be up to 6 years, not up to 4. All right, thank you. Now that I've told you what the allegations are, what your rights are, and possible consequences, let's see how you wish to respond. Now, because you've got counsel, I'll turn to Mr. Champion. Sir?
Your Honor, at this time, we would enter a not guilty plea to this matter, and we did request that this be set for a hearing, but I would ask that the hearing be set out at least 30 days. And the reason being is Ms. Bloss is currently in treatment and doing well, and I would like to be able to fully address that at a hearing. Thank you.
Thank you. Ms. Bloss, are you currently at a program? And if so, where and which program?
I am at Bear River Health. It's a rehab treatment center.
Yep, all right. So therefore, the defense is requesting to waive the 14 days.
That is correct, Your Honor.
Mr. Denout, any objection to the 14-day waiver?
No, Your Honor, we would support that, and not for the reason that we are prepared to go forward, but that would potentially impact the potential recommendation. So we just would support the request for the adjournment here.
I think it's fair. I don't find it to be prejudicial. I think there's good cause. If she's in a program, we want to maximize and help maximize the benefit of that program. Therefore, the court will order, however, that she must continue in that program. If she leaves the program unsuccessfully for any reason, she is to immediately report to the Missaukee County Jail. If she doesn't report to the Missaukee County Jail, well, that could also be a violation of a court order, which could be an additional probation violation allegation. All right. Any other questions or issues I need to answer for you, Ms. Odell?
No, Your Honor, thank you.
Mr. Denow?
No, Your Honor.
And Mr. Champion?
No, Your Honor, thank you very much.
All right. Ms. Bloss, do you have any questions about what we have done today?
No, sir.
Have you been able to hear us clearly today? The only reason I ask is because, all right, good enough. Thank you. All right, let's stick with that program.
All right,
We
thank
are
you.
adjourned.
Alrighty, friends, it's actually a little bit of a slow morning out in Courtlandia. That is not surprising given a Friday. Fridays often start off slow. But let's go back to Judge Anzalone. She has a new contestant.
All right, this is in the matter of the people of the state of Michigan versus Robert Warren Hamm, file number 26-22523FH and 26-22524FH. And Michael Dagger Margosian appearing on behalf of Mr. Hamm. Both are appearing via Zoom separately. I have Alexander Bayonetto present in the courtroom appearing on behalf of the people, and Thomas Moore from the Michigan Department of Corrections. Mr. Dagger Margosian, just so you know, I've already spoke with Mr. Moore about the PSI listing, Elias Mawad, so he will make those changes. So Mr. Dagger Margosian would like a breakout room with you, Mr. Hamm. So I am going to open a breakout room, and there should be a mouse there in front of you. And then you're going to get an invitation on the screen to join a breakout room, and just use the mouse and click to join the breakout room. Court room in the waiting room.
Well, that was a compelling little bit of video right there. You just never know what you're going to click into. We get to watch somebody get put into a breakout room. Happy Friday, everybody. Let's go back to Judge Elmore, new contestant.
Sagi. Our next our next case this morning is People of the State of Michigan versus Kelsey, Jackman, Sims. File number is 25-3596FH. Appearances, please.
Your Honor, David Inhofe on behalf of the people.
Michael Horowitz on behalf of Ms. Sims.
Ms. Sims is currently in custody at the Missaukee County Jail, serving a sentence. This court issued a sentence back on December 12th of 2025. The court sentenced her to 330 days. That was for a count of possession of a non-narcotic controlled substance. And she, one moment. How long did I put her in supervision for, Ms. Odell?
It was a jail only sentence.
Jail only sentence, yep, okay. By the way, Ms. Laura Odell is here from the Department of Corrections. Why are we on the record today? We're on the record because the defendant has filed a motion to this court pursuant to MCL 801.257 and relief from judgment as well under 6.502. The MCL statute that I referenced has to do with the court's ability to release someone early. I'm going to turn it over now to Mr. Horowitz. Mr. Horowitz.
Good morning, Your Honor. Thank you. I do have two documents that I would like to the court to receive. I don't have copies of them. I just received them this morning.
Okay.
The other 5 documents that I provided, I also provided to Mr. Denham by email. These two, one is a certificate of participation from Catholic Human Services dated 4/16.
Okay.
Okay, and the other is a letter from Ms. Sims' mom, Joyce Parnell, who's present here. And in addition to the people that placed appearances, Your Honor, there are, I believe, 4 individuals in the courtroom today on Ms. Sims' behalf. That's her mother, her aunt, a representative from CMH, and a representative from CHS.
Yep, I recognize the members from CHS and CMH. Also, the court's going to receive those. Did you take a look at those, Mr. Denham?
I did, no objection to the court's receiving.
All right, thank you. Before I take a look at those additional items, the court also received earlier this week a couple other documents from Mr. Horowitz. One is from CMH, specifically the social worker, Miss Van Houten. I did review that. And the next is a letter from Miss Platts. Also, again, she's the person from Catholic Human Services that we mentioned. I also have a letter from the Sunrise Treatment and Recovery Center. There's an intake coordinator there stating in the letter that there is availability for Miss Sims to enter a treatment program on August 20th. There is also an email from a person whose last name is Picard, and that would be the aunt that Mr. Horowitz mentioned. And a friend of hers sent an email, and that is Cody Harold. And I did review those actually yesterday. Okay. Now, with a quick look, again, I have a certificate of participation in Catholic Human Services. That's one of the 2 documents Mr. Horowitz provided. Now let me take a quick look at this other letter, and this is the one that is from Miss Sims's mother. Okay. All right. I've read that. Anything else factually you wish to present to me, Mr. Horowitz?
Your Honor, I think most of what I need to say is in the motion itself. Of course, these are kind of unusual requests to make to Your Honor. I know they're provided by court rule and by statute. That said, I think the court probably doesn't see a ton of them. Usually, when the court imposes a sentence, the court has imposed a sentence, and that's the end of the story. However, the legislature has recognized that we're giving courts the authority and discretion to revisit a sentence if the court feels that the person has excelled in certain ways while in custody. So a lot of the conversations or letters that I had initially received about Ms. Sims were kind of about, you know, her background or about the things that she had been through. And I really tried to distinguish to Ms. Sims and to the letter writers that what we're looking at is we're only really concerned with post-sentencing behavior, conformity, conduct, because Your Honor already considered all that other stuff in imposing it, in imposing the court sentence, right? So you were given pre-sentence investigatory guidance,
through MDOC probation. You were given arguments of counsel. And so you should, to the extent that those things were relevant, be aware of Ms. Sims' background, obviously criminal history, struggles, trauma, so on and so forth. So that's already, I guess, baked into the sentence. So that's not the point. The point is that since being sentenced, the people in Ms. Sims's life that she has contact with have indicated to me or to the court that they have witnessed or observed significant change in her demeanor, in her behavior, in her motivations to do better. She is also engaged in non-mandatory voluntary services involving substance abuse, rehabilitation, and personal therapy, personal psychological issues, and has been engaging in those things positively. She's also reached out to the outside and secured a bed or place or just, I guess, whatever with respect to the inpatient counseling. And so I think that she's demonstrated that she's really taken a lot of the court sentence to heart and has benefited from it, and that she probably doesn't need to have continued incarceration. And of course, it's a big ask, but I think she's given you a lot more information that didn't exist at the time of sentencing. That said, I will note that the people did file yesterday the evidence of the 2 infractions that Ms. Sims has had, or marked write-ups, whatever they're called, while in custody. And at least the second of those, to me, which I didn't identify because I believe it happened maybe after I had conversations about writing the motion, is probably more troubling than the first. The first, if your honor is familiar with it, there was an indication that the inmates were quote unquote exposing themselves. This was not the height of criminal behavior. My understanding, and the court could address Ms. Sims about this or just accept my representations, is that female inmates were comparing breasts. There was no ill will or criminality. It's embarrassing. I get it. Sorry. But that's the context there. The second, as to the misuse of the prescription medication, really the sort of, I don't know if you'd say mitigating factor of that, but is that I believe that Ms. Sims disclosed that. She admitted and acknowledged that to the jail in a way of saying, I need to be off of this. I need to not have access to this medication, is my understanding. And that may not be fully accurate, but that's just the gist I got. So the medication in question, I believe, is Visceral, which was an it's an antihistamine that's also used off-label for anxiety or something like that. Nothing that I'm particularly familiar with, but it's my understanding that she disclosed that misuse and just wanted not to have access to it anymore. So that said, I think she's given you pretty good documentation of what she's been up to and why you should consider reducing her sentence, at least to some extent. And I believe that Ms. Sims also has a letter or prepared statement that she'd like to make to you.
Thank you. I'll turn to Ms. Sims in just a moment. Mr. Denhouse.
Thank you. Some of the things I'm about to say are somewhat negative, so I want to start on a positive. Certainly, the people support every effort that Ms. Sims is making towards sobriety. And we do appreciate the fact that apparently she's been attending Catholic Human Services as well as community mental health, certainly supports those efforts. In reviewing, the file for this hearing, I did look at the transcript. I made note of the sentencing. Obviously, as has been referenced, there was no probation because of the defendant's conduct on bond. The court had indicated in the transcript, page 17, that every opportunity of grace has been provided to you. Essentially, what had occurred in this case is that the defendant was AWOL for several months. There were no less than 3 treatment facilities that she went to and left. One of which was the Sunrise, the one that the defendant is now seeking to be admitted to again. And there were 2 sentencings that have been scheduled that the defendant failed to appear for the sentencing. So that's some of the background. I think that the court's reasoning at sentencing was appropriate. We submitted the incident reports just to give the court some context. And we would take the position that the court's prior sentence was appropriate. And with that, we'll leave it to the court, Your Honor.
All right, thank you. Yes, Ms. Sims, is there anything you wish to say at this time?
Yes, Your Honor. I wrote some things down this morning because I'm not good at public
Okay.
speaking.
And you may sit down if it's more comfortable for
Okay.
you to.
Your Honor, I stand here today before you, a changed person. I've learned humility and a priceless life lesson, and I have to thank you for it. At the beginning of this, when I was arrested back in November, I thought everyone else was the problem and to blame for my actions. I wasn't taking accountability. I come before you this morning after spending the past 5 months in jail, changed, experiencing growth, and taking full accountability and acknowledging I've been the biggest problem in my life, nobody else. Going to groups with Nikki from CHS helped to plant that seed, so I'd like to take the time to thank her right now as well. Thank you. Since completing her 10-week course here in jail, I decided to make some more positive choices. If you so choose to extend me the grace, I decided to go back to inpatient rehab and do it for me this time. I've never done that. And attend sober living after. I've already been approved and have a bed waiting at Sunrise Center. I want to do better and be better. I'm extremely remorseful for my actions and how I have behaved. I can guarantee you, Your Honor, I'll be doing everything I can to never have to be in these circumstances ever again. I've sincerely learned my lesson, and I'm asking you to please consider granting either motion so I can continue on with bettering my life and proving that I've changed. Thank you.
Thank you. All right. I remember this well because it took us a lot of effort to get the case done, because Ms. Sims was impossible to supervise on bond, right? It took us like 7 months, if I recall, from the date of the filing of the felony complaint to district court until we can get it resolved in circuit court. And I specifically remember this because I wrote it on my copy of the PSI. And it said, no drugs, question mark. There's a page inside these pre-sentence investigation reports. It's called CFJ 145, page 1. And there should be at the bottom a list of drug, substances, and use issues. Didn't appear. Then when I look back in the section of that report, CFJ 284, and we get on the criminal history, and we get to a portion about substance use and treatment. There it said defendant acknowledged using marijuana at the age of 10, and then alcohol, and then cocaine at the age of 12. And then it went to methadone at the age of 18. And then made several attempts at treatment, including 3 attempts that we gave her back in last year, 11 months ago. She gave a statement that she was confident that she could complete any current inpatient treatment program. So what I didn't see in there is any section that described her drug history very well. Typically at drugs, it shows dates of start and dates of end. Well, what's missing here is a complete picture. It says methadone at the age of 18. Hold on. Well, she didn't mention that when she was 22, she got convicted of morphine. She also did not mention during her history, and it took going through her prior criminal history and her performances on bond and probation, she forgot that at the age of 28, her using methamphetamine. And then there was another use where her child apparently tested positive for methamphetamine. But still, I didn't see any references to that in her description and admission about substance use. So I remember exactly this case because I thought to myself, she wasn't upfront about her drug use. She said, oh my gosh, I'm just being convicted because they found one of my dog's pills. And she wouldn't do treatment. She has violated bond so many times. I went very thoroughly over her criminal history. I talked about the short gaps in time between convictions. I talked extensively about her probation violations, her bond violations. In 2010, she had one case where it was just an attempted retail fraud, and she had to have a bench warrant one time. Then she had 1, 2, 3, 4 probation violations. And those all began 2 weeks after she was sentenced. Then in 2013, when she got the use of morphine, she had another probation violation. And that probation violation came only 4 months after being sentenced, having just gotten out of jail. And then in 2016, there were multiple probation violations on the larceny in a building, and her probation, had to be extended. By the way, while that case was pending, she violated bond within 2 months of being on bond for one felony and picking up another felony. 2018, that case, she got convicted while on probation, and she had probation violations that began 2 months into her 6-month probation period. 2023, she was on probation when she picked up another charge. That one was for domestic violence. But she did make it about a year and like 5 months until she fixed up the charges for which she was convicted here. And actually, the offense date was December 4th of 2024. And the arrest date was December 7th, 2024. And because we kept giving her efforts, which she decided to thwart, because, hey, she doesn't mention all of the drug history, and this was just a dog's pill. So when she went into the jail, the reason why I didn't give her probation was because she was confessing that she didn't have a problem. Why did you thwart all those other efforts?
I wasn't taking accountability, Your Honor.
Yeah, I know. That's everything I'm saying. This whole PSI that you gave was an absolute farce.
The past 5 months, I've come out of the fog from using all them years, and I realize the mistakes that I've made.
Yeah. What credit does she have, Ms. Odell? So she had 35 days, I think, initially. So now she's up to 90. So hold on, wait. Should be somewhere around 120.
It's like 138.
I see Miss Odell's got her handy dandy cell phone out. You just do the, I call
Handy
it,
dandy date calculator.
yeah,
12/12 of 25 to present.
yeah, plus 35. Or she got the correct 35 days of credit, I think is what it was. Yeah, 35.
$126 days
Okay,
plus the 35.
plus the 35, so yeah, 162 days. That sends her to 330. At 275, so right now she's got another 120 days left to serve if she gets all of her good conduct done. So. I've got one question there about the statute. Just give me a minute. Put that in our book. 801, what is it? 801, 2 or 623 or something.
801-257.
I wasn't even close with that last three. Oh, it's probably easier if I pull it up on my phone. So please, no one think that I'm texting in a second. What was that again?
801-257.
257. Oops, I did it.
Any success, Your Honor, I have it in front.
Yeah, I've got it. Thank you. Yeah, see, I remember it being a very short statute as far as length. And it does just simply say that a prisoner or an inmate in a county jail may receive, if approved by the court, a reduction of 1/4 of his or her term if his or her conduct, diligence, and general attitude merit the reduction. Well, we've got some merit, and that is she's doing some treatment there in the jail, which is great. By the way, she has to. It's there for her. Whenever we've let her try to go do it on her own, she just took off running. So here's my thought process, and I know what my ruling's going to be, but here's how I get there. I can't amend a lawful sentence. That's what the court rules say. I lose jurisdiction of the sentence once I issue it, except when a statute like 801.257 allows me to come back and review it. But I'm only able to review it as to the amount of days that she's confined for the period. And that's my problem. The statute doesn't allow me to go back and give her probation, because there is no way I trust that Miss Sims will go do the program unless she has a hammer over her head. And the only way I could have a hammer is if I had probation. But at the last time we were in court, she had demonstrated so thoroughly that there was no way she was going to comply. And I just said, no, I'm not putting you on that, because you've told me you don't have a drug problem, that this was accidentally a dog's pill in your bag or purse. So I gave you no probation. I cannot pursuant to that statute give you probation. I furthermore cannot pursuant to the court rules amend a lawful sentence, which means I can't add probation. And because I will not let you go to a program, because I have no ability to supervise you, you can go to the program when you're done serving your 330 days minus your good conduct time. Because at least I know there, not really that I observe you, I've got no idea, I don't watch cameras or anything. By the way, apparently according to one of these, I'm glad I didn't, but there, I've got people that are doing good things for you. I think the world of Ms. Platts and Catholic Human Services and CMH and the services they are able to provide. Therefore, I'm going to let you still get their benefit. Thank God we are able to use opioid funding money and MRE money to get Catholic Human Services into the jail. And then when you get out, hopefully you never come back to the courtroom here. Because if you do, and you do not leave this jail service and go get that treatment, I will remember this conversation today. And then I'll say, well, I thought you could go do it on your own. So I hope you do. I really do. And I would, if that law allowed me, if the law did allow me to amend a lawful sentence, other than the reduction of the 25%. But it doesn't. And I don't trust that you're going to go do the program. So I'm not going to give you 150 some days or whatever it is for you to maybe go do it. Yes, ma'am.
If it was reduced by 1/4, I still wouldn't get out until the end of May. I still
Yeah.
have another month.
I know, but here's the reason. My sentence was lawful and you are still having a problem because as of a month ago, you were snorting your own meds. You aren't being, so when I look at even that statute, while you're doing some good, you're not doing enough good because you're also snorting your prescription meds and a histamine. So that counteracts, so that basically balances the two out. And your performance before, when I sentenced you, was enough to tell me and to tell me that the sentence I gave was spot on. You had reasonable ground, you gave me so much reasonable grounds to give you a jail sentence, despite that it's a maximum of 2 years and that it is an intermediate sanction cell. Had you ever taken advantage of any of the opportunity that we gave you, it'd be different. Yes, ma'am.
I was on heavy drugs at the time. I'm not the same person.
I know.
Like I want this more than anything.
I want you to have it too, but I can't do it where I know that I can make you do it.
What about even with the tether?
I can't. I can't amend a lawful sentence unless otherwise specified and permitted by law. The statute that we've talked about today does permit me by law to reduce the jail period,
Correct.
but doesn't allow me to modify and add probation.
Would you consider reducing it?
No, I'm not going to, because I know at least there, Ms. Platts is going to help you. She's going to continue to do a fantastic job for you. I have zero doubt.
I've completed her.
I know, well, yeah, but I think there's always extra stuff there, okay? And Ms. Platts isn't gonna go, well, I already gave you a certificate. You can't come back here.
Right.
So, Ms. Sims, I want you to get better. I really do. But here's the thing. Sometimes there have to be consequences. And you're snorting your prescription meds. So the answer is no. Therefore, the court respectfully, and I do appreciate Mr. Horowitz's effort here. He does a heck of a job every time he comes in. And I'm not just trying to suck up to him because he puts on a good effort and I appreciate people really well. But next time, no, I mean,
Next time.
I hope, I really do. I truly, Ms. Sims, want you to get out after serving your time. And I want you to continue with this pursuit. And I want you to get that treatment. And then I want someday you come, stop by, knock on the door, come sit here in court and tell me, hey, Judge, just to let you know, I did what I said I was going to do. I will be happy. Then if we have coffee, I'll get coffee. All right.
Judge, may I
Yeah.
just add one thing?
Sure.
And I don't want to belabor it, and I
I know.
certainly don't want
It's
to
okay.
argue, but I would just suggest, Your Honor, that you could consider kind of the traditional statutory construction that we are generally able to construe a statute's meaning and scope and authority in such a way as to give the legislature's words effect, right?
Yeah.
And so I think that I agree that this is a very, not so much narrow, but sparse statute that doesn't give much guidance. It's short. It's extremely short. There's like one operative sentence, right?
Yep.
I think that you could construe that it's in such a way as to give it effect by saying that the legislature is recognizing or vesting in you the ability to reduce the sentence by up to 1/4. But I don't think that the legislature would want to limit the tools in your toolbox, so to speak, as to give that effect. So I think that the legislature would likely not take issue with attaching some other monitoring or rehabilitative measures to that reduction.
I appreciate it. I chuckled, and I'm sorry, I didn't mean to disrespect to Miss Sims or Mr. Horowitz, because no, I see the legislature all the time trying to take away and whittle down my discretion and take it away. So I don't give them any benefit of what their, unless their words specifically say it, because if I do exercise anything thinking I've interpreted their legislative language and they don't like it, they will swat me hard with an appeal. So nope, I don't give them any such leverage or interpretation, because they don't give it to me. They want to limit trial court judicial discretion. Plus, again, I also know that the court rule, which is also comes down not merely from the legislature, but also from the Supreme Court, does not allow me to amend a lawful sentence. So therefore, I would have to not only disagree with the legislature, but I'd have to disagree with the Michigan Supreme Court. And I can't do that. So, all right, thank you. We're adjourned. Mr. Horowitz, there's an order already inside the file. Yep. There's your.
Morning once again, everybody. Happy Super Friday. My name is Dan. Welcome to TCF Live. Judging from the stats, there's some new people out there. If you're new to the channel, feel free to say good morning in the chat. We are a friendly folk here. We will welcome you with open virtual arms. GG, 4 months with me. Thank you so much. I appreciate all your support. Behind the scenes, GG has kind of quasi treated me as one of her own. And GG, I want you to know that that means a lot. I very much appreciate all the love and support that you give me and that you give the rest of the community. Yeah, it's interesting, as this last 18 months has gone on, we bring people into the community and then you can't imagine the community without them. Gigi, you are one of those people where I can't imagine not having you here. So thank you so much for being with us. Okie dokie. It feels like I'm bouncing between Elmore and Anzalone this morning, but that's kind of what we got at the moment. There's actually a decent amount of courts going, but not a lot of compelling stuff. So we're just going to stick here for now. Back to Judge Anzalone.
Heard in file number 26-22523FH and 26-22524FH with the matter of the people of the state of Michigan versus Robert Hamm. So, Mr. Degemargosian, have you had enough time to speak with the client?
Yes.
All right. Mr. Hamm, have you had an opportunity to read and review the pre-sentence report?
Yeah.
All right. And you've had an opportunity to speak with Mr. Degemargosian?
Yeah.
All right. Are you satisfied with Mr. Degemargosian as your attorney and the advice that he's given you?
Yeah, I guess so.
Okay, so he's answered all your questions
Yeah,
and you're satisfied that he did his best to represent you.
yeah.
Okay, Mr. Dagger Margosian, do you wish to, yeah, now obviously we've already made the correction to the attorney counsel name, but do you wish to explain or challenge the accuracy or relevancy of any information in this report?
No, Your Honor.
Mr. Alexander Bayanetto? All right, now, obviously, there was a Killebrew agreement that was struck between the prosecutor's office and the defense counsel. So the court will honor that, of course. Does the pre-sentence report disclose any prior convictions in which there exists any known constitutional defects? Mr. Dagger Margosian?
No.
And Mr. Bayanetto?
No, Your Honor.
The probation department has calculated the minimum sentencing guidelines on hold on one second, on file number 26-22523 to be 0 to 17 months. Do you have any objections to that calculation of guidelines, Mr. Dagger Margosian?
Your Honor, no challenge at this time.
Mr. Bayanetto?
No, Your Honor.
On file number 26-22524FH, probation department has calculated the minimum sentencing guidelines to be 0 to 9 months. Do you have any objection to that calculation, Mr. Dagger Margosian?
No challenges at this time.
And Mr. Bayanetto?
No, Your
All right, before the court passes sentence, do you have anything to say on behalf of the people, Mr. Bayanetto?
Honor. Just that, Your Honor, Ms. Arnold, Mr. Dagger Margosian and I discussed this case for a long time. That's how we came up with this resolution. That was in conjunction with the victim's request. They are not here to make a statement today. So I would just ask that the court follow the Killebrew agreement.
All right, and Mr. Dagger Margosian, anything you'd like to say on behalf of Mr. Hamm?
Your Honor, the sentence is fairly straightforward as the conditions have really been carved out in by way of the plea. I would ask obviously the court that the court grant the credit, the 130 days on 523, the 144 days on 524 for the sentence to be concurrent. The only condition that I think is inappropriate is the condition for Mr. Hamm while on probation to not have any contact with anybody under the age of 17. Neither of these offenses involved anybody under the age of 17. Obviously, sentencing is supposed to be crafted in response to the offense itself. So I don't really understand why those conditions are in there. Mr. Hamm is these offenses do require SOAR compliance. So obviously that can be handled, but by way of a probation condition, I think that's inappropriate. And I would ask the court to not order that at this time. But other than that, I'd ask the court to follow the recommendation.
All right, Mr. Hamm, is there anything you'd like to say on your own behalf?
You know, I'm talking about under those lines.
I'm sorry, Mr. Hamm, that room has really bad audio. It's not your fault. Could you repeat that?
You're talking about what being about the 17 limit?
No, I just meant in general, including that. Is there anything you'd like to say on your own behalf before I pass sentence?
Nothing I can think of right off.
Okay. In determining the appropriate sentence in this case, the court has considered the seriousness of the offense, your history, the principle of proportionality, the statutory penalty, the cost of confinement, the sentencing guidelines, the report and recommendation of the probation department, as well as what has been said upon the record at this hearing. The criteria and reasons for the sentence are the nature and gravity of the offense, the discipline appropriate to its commission, deterrence against repetition by you and by others, the potential for reformation, vindication for the law, and the protection of society. Mr. Hamm has no prior misdemeanors. He has one prior felony. He has a very limited criminal record. It was a Killebrew agreement placed on the record, agreeing for a sentence of 5 years probation and 1 year in jail. It's a sentence of the court that Mr. Hamm will be placed on probation for a period of 5 years. During that term of probation, he will obey and comply all provisions in the articles of probation, not limited to, but including, he's not to violate any criminal law of any unit of government. Do you have children, Mr. Hamm?
All I know is a 37-year-old.
Okay, do you have grandchildren?
Yeah.
Okay. Mr. Moore, this incident, as correctly stated, did not involve a juvenile in any way. Was there a mandatory reason you put that clause in there?
Yeah, we have, well, there's two offenses here, and one of the victims was probably mentally underage, but he has a previous sex offense from what, 1990 or 91 or 2, and just his behavior and whatnot, we would appreciate that condition stay in place unless there's some specific reason he needs to be around somebody that's underage.
All right, I'm not, okay, so I'm gonna order that you're not to have any verbal, written, electronic contact with any individual age 17 or under, or unsupervised physical contact with any individual under the age of, or 17 and under. Complete sexual abuse prevention programming or other treatment if referred. You must register as required by the Michigan Sex Offender Registration Act and comply with all the requirements of that act. Provide verification of your registration. You have to register every so often as required, and I believe Mr. Moore would provide that information to you when you report. You must not access the internet using. Did this involve the internet?
I don't believe so, Your Honor.
No.
I'm not going to order the internet clause, Mr. Moore.
Okay.
Okay, because he's going to have to
They
get
do
a
request
job.
us to ask for that, whether you grant it or not, but we're, required to request it.
Okay, I'm not going to require it, so
Okay.
just because I don't think it has any bearing on this case. Now, obviously, you have to waive confidentiality and require what? I don't even know what number 7 means. I've never seen that one before. Mr. Moore, I apologize. Is that a new one?
Yes, give me a second here.
To facilitate
Nope.
sexual offense caseload management team meetings? I've never seen that one before. I'm sorry.
They're asking us to add those on there. This is waiving confidentiality for the he's going to be placed in sex offender therapy. So that's what that is.
Okay, so it's just the typical term that.
It's waiving
yes.
confidentiality for the team of people that will be involved with it. Yeah.
Okay. I'll order that as well. Can't leave the state without consent of the court, not to use any illegal controlled substances or paraphernalia. Report as required to the probation department. Notify them immediately of any change of address or change in employment. Not to have any contact in any form whatsoever with the victim in this matter. And you can't be within 500 feet of their residence, their school, or employment. And so that would be Kathy Watering Lally and Kimberly Gerber. Not to provide any care for any adults age 62 or older, for any disabled adults. Must have ID or a valid driver's license. Not to engage in any assaultive, abusive, threatening, or intimidating behavior. Submit to search of your person and property, include your vehicle, your residence, your computer, without need of a warrant if they have reasonable cause to believe you have items which violate the conditions of your probation. And this is, I'm sorry, Ms. Spade, all on file number 26-22523FH.
Thank you, Judge.
You will serve 1 year in jail with credit for 130 days already served. There's a crime victim assessment fee in the amount of $130, $30 per month supervision fee, $60 if we have to put a tether on you. Pay court costs in the amount of $750, a DNA fee in the amount of $60. I think he's already complied with that HIV testing. If not, you will have to comply with that and sign a release of information on that to the probation department. Crime victim assessment, there's a state cost of $68, but I don't see that on there. Okay. On file number 26-22524FH, obviously all the same terms of probation for a period of 5 years. Okay, this one's a little different. He must not live in a residence where any individual age 17 or under stays or is cared for, not provide care for any individuals age 17 or under. What was the age of the victims in this matter? Mr. Degmar,
They were both adults. I was gonna say.
like adults?
Yeah, like not
Somewhere
somewhere
between
like
30
30s,
and
yeah.
late 40s.
Yeah.
Okay, you're not to have any unsupervised contact with anyone under the age of 17 or 17 or under. You must get permission from the court and the probation department if you're going to live in a home where someone is age 17 or under. You must complete your sexual abuse prevention treatment program, register as a Michigan sex offender, provide verification of that. Again, I'm not going to do the internet use. The other terms remain the same as the other file. No contact with the victims in that matter. Again, not provide care for anyone 62 or older.
May I ask a question?
Yes.
Yeah, I know, like, there's this lady that I know that she's older than that, and she's been wanting to be my girlfriend for a long time. She's she's in her 80s.
Okay, so what I will tell you is, is she disabled?
No, not exactly. She's
Okay, well, before you date her, I guess you need to talk to Mr. Moore about her, all right? And make sure she isn't in any way have anything about her that would violate these terms.
okay.
Mr.
Your
Moore?
Honor, I just wanted to clarify something with that condition 7, the internet access. We're not, it's not asking him that he doesn't, get on the internet. It's that we want him to complete and sign an MDOC internet use agreement, which puts some guidelines down. That's what that condition is.
And that's fine. Okay.
Does that mean I can still use Facebook?
Right. There's going to be an MDOC agreement, so you understand what you can access and not access. So.
Well, what is he limited in accessing?
Well, I don't have it right in front of me right now to go through everything, but it's going to make sure that he's not on sites that he shouldn't be on.
Okay, so Mr. Moore, I've not seen this one before in a PSI, and so even I have some concerns about that. So what I would say is, obviously, I mean, it shouldn't limit him from social media, internet access, or whatever. So what is it trying to limit him? I'm sorry, Mr. Moore, to hit you with this. I've just not had this clause before. So what would it limit him from doing?
Why don't we could just not put it on there, and I will get an agreement, to you late, at some point, so you can, because you'll see this in the future, and so we can, whether you agree or, decide to agree with it or not, but we'll have the, so that you're aware of it.
Okay, and could you get that to me, Judge Olsaver, and also Mr. Deger-Margosian? Okay, thank you, and I'm sorry about that, I just wasn't, okay. So understand there may be some limitations on your internet abilities, but yes, you shall be able to use your Facebook, okay?
And not only that, what if I have a cousin that wants me to help him work on his truck, and he lives in Ohio, in Pioneer, Ohio?
Well, that's not, you got travel restrictions. Everybody does.
Yeah, you can't go to Ohio. Sorry. The cousin might have to trailer the car to you to work on.
And I've been helping him
Okay.
work on a pickup.
Well, then maybe you better trailer it to Michigan. All right, submit search and seizure of your property. I'm gonna order you serve 1 year in jail with credit for 144 days. There is $130 crime victim assessment fee, $68 in state costs. There's no supervision because he's paying it on the other file, right?
We order them on both in case one discharges before the other, and so it's only going to be one fee though.
Okay, and $30 per month supervision fee, 60 if we have to put you on a tether. And that's only, you only paid on one, not both. So is there anything else, Mr. Moore?
No, Your Honor.
Okay, so, sir, when you are done with your jail term, you will need to report to the probation department the next business day. Do you understand? So if you get out in the morning, come that afternoon and check in. But if you get out during the middle of the night, I think they like to let you guys out in the middle of the night. You would just have to be here by 8 o'clock the next morning, all right?
Yeah.
Okay. Anything else, Mr. Moore?
No, thank you.
Mr. Bayonetto? Mr. Dagger-Margosian? No. All right, now, Mr. Hamm, you do have a right to appeal this sentence. We are going to provide to you 3 copies for each file of your notice of right to appellate review. They'll have you initial and date 1 copy for each file for our records. That's just to verify that you received a copy of your appellate rights. If you wish to appeal your sentence, you would fill out the information on the form and mail it to the address listed on the form within 42 days. All right?
Yeah.
Okay, all right, thank you, Mr. Hamm. Mr.
Alrighty, friends, TCF Live. Happy Super Friday. About a little over an hour and a half to go yet. Let's go to Royal Oak, Michigan, Judge Andrew Kowalkowski.
Mr. Epstein, I see you're connected, but I don't see your video. Are you there, sir?
Yeah, can you hear me?
Yep, can hear you just fine.
I'm not sure why this is not.
Well, I think we can proceed as is here. So this is case 25-00812FY. It's State of Michigan versus Timothy Tabron. Appearances, please.
Fair you on behalf of the people.
Jonathan Epstein on behalf of Mr. Tabron.
Mr. Tabron, your name?
Timothy Tabron here.
All right. This is the date and time set for continued hearing on the motion. The court had adjourned after hearing arguments from the parties last week and wanted to look over the briefs and consider the arguments further before delivering its ruling. Any updates, any preliminary issues? Obviously, the time for arguing and adding any evidence to the motion filing is concluded, but were there any additional updates before the court delivers its ruling this morning, Ms. Ayub?
Nothing from the people, Your Honor.
Mr. Epstein?
Nothing for the defense.
All right. Court has considered the arguments, read through the motion. The initial motion was filed by the defendant here in this case in pro per. And then we held arguments. People did respond, and then Mr. Epstein did also have a chance to reply in writing. The courts read all those and considered those along with the arguments that the parties gave at the motion hearing. I'll start first with the 180-day rule. That was the initial focus of the motion that Mr. Tabron had filed. That's a statutory right that inmates have to be brought to trial within 180 days after the Department of Correction, quote, causes to be delivered to the prosecuting attorney of the county in which the warrant, indictment, and information or complaint is pending, written notice of the place of imprisonment of the inmate. And that's pursuant to MCR's 6.004D1 and MCL 780.13. As I mentioned, that's a statutory right. And so according to People v. Rivera, that's 301 Mishap 188 and at 192, a 2013 case. There, the court held that the statute 780.131 subsection 1 provides that the MDOC must send written notice by certified mail to the prosecutor to trigger the 180-day rule requirement. And in that case, they held that because the MDOC sent a notice to the district court but did not send by certified mail a notice to the prosecuting attorney, the 180-day rule was never triggered, so it could not have been violated. According to the court file, the record, and the court's understanding of the position of the parties here at the hearing, the arrest in this case occurred on March 1st, 2020. Make sure I get the year right, 2025. The complaint was sworn to and the warrant was issued May 12th of 2025. The notice from MDOC was not sent to the Oakland County prosecutors until January 23rd of 2026. Thereafter, Mr. Tabron was arraigned on this matter February 27th of 2026. So according to the statute, the clear language of the statute and the interpreting court opinions, that clock on the 180-day rule did not start running until January 23rd, 2026. Accordingly, we have not reached the 6-month period there, and there is no violation of that 180-day rule statute in this case. Now, in Mr. Epstein's reply and in the people's response, they both went on to consider the constitutional right that Mr. Tabron has to a speedy trial. And so I think it is appropriate for the court to move on to that issue and address that. Of course, Mr. Tabron has also a right to a speedy trial. That's guaranteed by the U.S. Constitution and the Constitution of Michigan. Defendant and the people are entitled to a speedy trial and to a speedy trial resolution of all matters before the court. That's MCR 6.004A. The time for judging whether the right to a speedy trial has been violated runs from the date of the defendant's arrest. That's People v. Patton 285 Mishap 229 at 236, a 2009 case. To preserve the issue of speedy trial for appeal, a defendant must make a formal demand for speedy trial on the record. People v. Kane 238 Mishap 95 at 111. As we've talked about in the motion hearing, there are the Barker factors that the court must consider when considering this type of an argument. Those factors include the length of delay, the reason for delay, the assertion of the right, and any prejudice against the defendant because of the delay. Here, starting first with the length of delay. Going back to the arrest date, we're at about 13 and a half months since arrest. And there is in the case law a reference to an 18-month mark where anything prior to an 18-month delay, the defendant bears the burden of showing actual prejudice by reason of the delay. Then that's People v. Holzer 255 Mishap 478 at 492, a 2003 case. And since we are less than 18 months from the moment of arrest, it is the defendant's burden then to show actual prejudice. The reason for the delay here is that the MDOC failed to notify Oakland County Prosecutor's Office any sooner than January 23rd, 2026. And because that's the case, the court can't draw any kind of negative inference against the prosecution in this matter. It was not their delay. There was argument at the motion hearing that they should have known where Mr. Tabron was, given the fact that MDOC took custody of him from the Royal Oak Police Department, and that there was further probation hearings that took place. But the case law does not bear out that should be drawn against the prosecution in this court's opinion. The fact that those things were ongoing, ultimately it was MDOC's duty to notify the prosecution, and they failed to do so in this case. And so I don't believe that the reason for delay can be drawn against the Oakland County prosecutors in this case. The assertion of the right, the third factor, in People v. Missouri, a Michigan case 100 Mishap 310 at 322, a 1980 case, the Court of Appeals concluded that the defendant's assertion of the right to a speedy trial 2 weeks before trial and nearly 30 months after indictment was strong evidence that the delay had not caused a serious deprivation of their right to speedy trial. Here, Mr. Tabron's first assertion of the right occurred with his filing of the motion. At least that's what's reflected in the court record. I know counsel made arguments that he had begun a lengthy process of investigating and putting together a well-crafted motion that he filed in pro per. But the assertion of the right, the first indication that this court can conclude occurred with the filing of the motion and nothing before. So that assertion of the right was relatively recent, and accordingly, again, there wasn't a prior assertion that was ignored by the prosecution or the court in any event. And so there again, I don't believe any negative inference can be marked against the prosecution. Finally, the court is to consider the prejudice because of the delay. There's two types of prejudice, which we talked a lot about in the motion hearing. Defendant may experience that's prejudice to his person and also prejudice to his defense. That's People v. Smith, a 2024 case from the Court of Appeals, currently without citation, unreported. And then also in People v. Jones, they held that the prejudice to the person that the defendant I argued occurred outweighed by the notable lack of any prejudice to his defense. Here, there's really no doubt that this delay did result in some amount of personal prejudice to Mr. Tabron, but any prejudice to his defense at this point is not apparent to the court. The delay certainly will have some effect on witnesses' memories. But the prosecutor alleged and was uncontroverted that all other recorded evidence and video recordings and things along those lines are preserved and available and should not impact Mr. Tabron's ability to have the full discovery in the case. The impact on memory, at least at this point, will be something that the trier of fact will have to determine what weight to give evidence given the delays that have occurred in the case. So again, I don't believe that there's been any prejudice shown to his defense. And while there is prejudice to his person, the notable lack of any prejudice to his defense outweighs that personal prejudice. And so for those reasons, the court also does not find that there's been a constitutional violation of Mr. Tabron's right to speedy trial at this point. He has obviously preserved this argument by filing his motion, and we'll have an opportunity to have this further addressed should things continue to be delayed or whatever he chooses to do in the future. But at this point, the motion's denied for the reasons that the court just went through on the record. With that finding, the court does have some additional questions here. Mr. Epstein, my understanding is that your limited appearance concludes then with this court's ruling. Is that still accurate, sir?
Yes, Your Honor.
All right. And so then, Mr. Tabron, I'm going to address you here briefly with the next steps. Is it your request then to have the court direct the MIDC or the Public Defender's Office assign you new counsel?
The public defenders should assign me new counsel. And I was also wondering if there was a way that I could maybe do a negotiated plea or talk about a plea, an early plea.
That's
you need to speak to an attorney first,
right,
Mr. Tabron.
So we'll make sure that this happens as expeditiously as possible, Mr. Tabron. But you should be represented throughout that decision as you move forward. So the court is going to then direct MIDC to assign new counsel, and we'll adjourn this.
I'm just concerned, Judge, especially now that these issues have been raised. And you know, the 180 days, I believe, is July of this year. And if it is determined that there's going to be an exam and moving that forward, so would it be possible to set it for next week and then hopefully have MIDC have someone assigned? That way, when we need to set an exam date, if that's where we're headed, we can do that the following week.
Yeah, I think let's set it for next week. And if for whatever reason there's delays on the part of MIDC or the Public Defender's Office, we'll address that next week. But I think that, you know, Mr. Davenport certainly was apprised of what was happening here in this case, in this motion hearing. So my hope is that they will react quickly, and I'll make sure the court clerks explain the situation, and hopefully we can move forward. Ideally, the court would like to see Mr. Davenport reassigned so that we can just move forward with a consistent representation. If that's not the case, we'll address it as we go here. And the court also, I just want to address one last open thing before I turn it over to the parties for any additional comments. the court made reference to needing to assign this portion of the delay to one party or the other. Upon further reflection, I don't really think that's this court's role. The record's clear on what's happened, and any reviewing court later on would have to make that determination on who to assign this period of delay to. So I think the record's clear on what's happened, and I don't have any issue with that. So I'll anything else from the people, Ms. Ayub?
No, Your Honor, thank you.
Mr. Epstein?
No, Your Honor, I just want to apologize for my camera not working. I don't know why it's not working, but.
No problem. All right, Mr. Tabron, we will see you next week. I guess my last question, should we attempt to try to keep Mr. Tabron at Oakland County or allow him to return to MDOC at this point?
Your Honor, for next week's purposes, I would say keep him at Oakland County. And the only reason I say that is because if we are going to hold an exam and he needs to be here in person, I'm going to have to writ him out, and that's a 3-week process. So I think it makes sense until next week till we figure out what's going on to keep him at Oakland County. If at that time he speaks to an attorney, is going to waive, he can be released back to MDOC. If he wants to have an exam, then he's already here for us.
Mr. Epstein, you're still here today and in your limited capacity. Do you mind if I address that question with Mr. Tabron?
No objection.
All right, Mr. Tabron, let's just keep it limited to this current issue. I don't want you to talk about anything with the pending case or not, but it seemed to me that your desire would be to return to MDOC. Is that fair?
Yes, sir.
All right. I understand your concern, Ms. Ayub. I think the record is clear here. Mr. Tabron is kind of what his preference would be to return to MDOC. And with that representation, I don't have an issue with just leaving this as is. We'll adjourn it. I don't know that's for sure what's going to happen, Mr. Tabron, because this is a short turnaround. But we'll just leave silent as to what should happen with your custody, whether you remain in OCJ or return to MDOC. I imagine you'll go back to MDOC, but we'll stay on top of making sure you're connected by Zoom, and we'll go from there. Okay.
All right.
All right. We're all set for today. Take care.
Thank you. Good luck, Mr. Tabron.
Thanks.
Alrighty, friends, let's go back to Judge Elmore, new contestant there.
All right, Mr. Burke.
Good morning, Your Honor. I'm sorry, did you call one of the cases?
I did. I called both the Sagi matters. Now I'm asking for appearances. Go for it.
Sorry, Your Honor, I didn't hear you call the case. My apologies. Your Honor, for the record, Mark Burke, P54935 on behalf of the Attorney General's Office for the People.
Thank you.
May it please the court, Robert Champion appearing on behalf of Ms. Sagi, who is seated to my left, Your Honor.
Thank you. Whenever I hear that old style phrase, may it please the court, one of these days I'm just going to go, you know what? No, it doesn't. No, that's okay. All right, so here we are today for a sentencing. Also before the court today, in addition to Ms. Sagi, is Ms. Laura Odell. She's an agent with the Michigan Department of Corrections who has prepared today's pre-sentence investigation report. The report applies to both 3636 and 3637. It's a relatively short report, or at least it doesn't have a lot of stuff that I would normally point fingers to. Mr. Burke, any challenges, amendments, corrections, or objections you wish to raise as to the PSI?
I'm trying to look, Your Honor. I just the one thing I can tell Your Honor is I don't have any real substantive changes regarding and most things in the report, but I can give Your Honor an updated arrearage amount in both cases if Your Honor would like.
I would love it. Let's hear it.
All right, in file, I believe 253636. The current arrearage in that case, Your Honor, is $5,216.93. That's the number I have as of 2 days ago. And in file ending or in file 253637, the arrearage that I show as of 2 days ago is $11,644.71.
All right.
Based on those numbers, I was gonna say, Judge, based on those numbers, a couple things. First of all, I didn't see that the bonds were applied in either one of those cases. And I think that was supposed to be done before today's date. In addition, I know that the defendant was going to be placed on delayed sentence if she was paying as ordered, but I just want to make sure the court is aware that based on my records, what I've seen, the defendant's making payments through a wage income withholding order, but it's not enough to pay the 138 a month in the current support obligation in case 3636, and it's not enough to pay the 315 per month on case ending case 3637. So I want to make sure the court is aware of that. So I know the idea in this case was to put the defendant on delayed sentence. I don't think she's eligible for that, at least not right now, based on what I've seen.
All right, one moment, I'm going to address the first question, then that it was the application of bond. Madam Clerk?
That would be my fault, Judge.
It's okay. As long as you admit it out loud on the record.
He did not do an order after the last hearing.
All right, so we will.
We will take care of that.
All right, so separately, Mr. Burke, I will sign an order that takes the bond that was posted and it will be applied to the files. All right.
Okay, yeah, that's fine, Your Honor, no problem. Thank you.
All right, now let's take a look here at the next question. And so the question now is, when I look at the Killebrew agreement, there were two conditions. Condition number one is that the bond would be applied to the arrears. We've just done that. The next question is whether or not she has continued to pay child support per month as ordered. Now let's take a look at that. And it says pending sentencing. Ooh, that's a good, interesting read right there. Pending sentencing. Does that apply until the day, or does that apply until the delayed sentence? Because when I delay a sentence, I'm not doing a sentencing. Interesting. All right, go ahead, Mr. Campion.
It is, Your Honor. It's interesting from the standpoint as counsel and the court's aware, only approximately 50% of a person's salary can be held back for child support, and that's what's occurring in this matter.
Okay.
There is an income withholding order in place. They are taking the maximum amount out of her paycheck in this matter. My client is fully aware of that, so the court's aware, and she is looking at getting a second job to try to catch up and pay everything off.
Okay.
But she is trying to comply with the court rule, but unfortunately, finances are a little tight.
All right, thank you. Mr. Burke, so now, wait, hold on. Before I turn to Mr. Burke, let me ask Mr. Champion, any challenges, corrections, or amendments to the contents of the PSI?
None, Your Honor.
All right, so we've got that done. Now, Mr. Burke, I need to turn to you. Haven't heard what Mr. Champion has said. Are the people willing to continue with the Killebrew agreement? I can amend the language. It says she has to pay her monthly child support to the maximum amount allowed under the required by law, I guess is the right way to say it. But what's your position, sir?
Well, Your Honor, thank you for that. I appreciate that. So a couple things. First of all, whenever a defendant has a current support obligation, and I've been prosecuting these cases for 23 years. So I've seen these cases. Yeah. So when a defendant's when a defendant has a current support obligation and part of the deal is to place the defendant on delayed sentence, I mean, the fundamental foundation of the entire plea is that the defendant has to stay current on his or her current support obligation. I mean, that's because if they're not, then the arrears is growing. It's getting bigger. I got it. And so, and that's what's happened in this case. So, I mean, I'd like to see the. Go on. I'm sorry.
I totally agree. By the way, you've done these cases for 24 years. I hope you've done other kinds of cases.
No, my practice is pretty diverse, Your Honor. I'm a special assistant,
Okay.
so anyway.
If I had to do child support, if I had to do failure to pay child support cases for 24 years, I don't know what I'd do. But anyway, so the only question I've got for you is, what do the people wish to do? Do they wish to continue and have her hear all this and know that she's, no matter what the rules are for with deductions for pay.
Well,
That she
quite
has
frankly, Your
to.
Honor, I like that there's an income withholding order in place. That's great. I like the fact that we're going to apply the bond now in each case. That's great. The arrearages aren't extensive. They're not massive. They're manageable, in my opinion, based on my experience. I'd like to give the defendant an opportunity, but what I'd like to see is maybe we adjourn for 30 days, see if she gets her second job, see if she, because she really, quite frankly, Your Honor, like, for example, in file 3636, the current support obligation is $138 a month. Her payments are about, I think, $60 a month that are going to that case. So, it's just growing. I'd like to see her at least make the current support obligation in both cases.
And if I grant the request to adjourn, it gives Ms. Sagi additional time than just a 1-year delay.
Correct.
That makes sense?
It does, Your Honor, and I have no objection to that.
Even a
Ms. Sagi?
60-day adjournment, of the delayed sentence, whatever the court wants to give her, that's fine. She's making payments. I just want to see her get the payments to that level.
I got you, sir. Mr. Burke, yeah.
I would ask for the 60 days.
I'm gonna go 60 days. Any objection to that? All right, good job. Good choice.
Thank you, Your Honor.
All right, the court's going to, now that we've got this question, and I find that there's good cause to grant the adjournment of sentencing based upon the quote unquote confusion potentially about getting these child support payments made and how much she has to pay, what can be taken out of her sentence. And I don't know how old Miss Sagi is. Don't say it out loud because you're a woman, but it's a lot younger than myself, Mr. Burke and Mr. Champion. So let the three of us kind of talk fatherly. Whatever you're spending your money on, get rid of stuff. Hopefully you're driving a beat up, rusted out car. If your car looks anything nicer than mine, then you need to go sell it and get something cheaper. Okay? And if you're out there using, say, recreational marijuana, throw that away. And if you're out there going out and hanging out and getting pizzas every Friday night, screw that. Just go to G&D because it's still only $1.25. All right. Thank you very much. We will adjourn today's sentencing and we'll get a new date ordered by my clerk. I don't know what it is, Mr. Burke. So there we go. We'll see you all in about 60 days. Thank you. Yep.
Alrighty, friends. I hope you're having fun this morning. I know I am. TCF Live on a Super Friday is always the place to be. Let's go to Texas, Judge Boyd, where things are just kind of turned on their side this morning.
Okay. And is his client here? All right. So we'll go with Mr. Salinas first. Cindy, are you ready?
Yes.
Court is calling 2026 CR 000273. State versus Luis Salinas. Can I have parties announced for the record?
Greg Desmarais for Mr. Salinas.
And are you Mr. Salinas?
Hello. Yes, ma'am. Oh, yes, I did.
All right. And this is an application. Counsel, have you received all discovery? Did you review it with your client?
Yes, ma'am.
Court will find that the state is in compliance with discovery. Mr. Salinas, did you review the consent to plea by video conference with your attorney? Did you understand it and sign it and electronically sign it?
Yes, Judge. We did, Judge.
All right. Court will find that defendant has no voluntarily consented to appear by video conference. Mr. Salinas, did you review the application for community supervision and electronically sign it?
Yeah. Yes, Judge.
Did you review the true bill of indictment with your attorney? Did you understand it?
Yes, ma'am.
Counsel, do you waive the reading of the indictment?
We do, Your Honor.
State, are you proceeding on the indictment as presented?
No, Your Honor, we waive count 1 and proceed on count 2.
Any objection?
No objections, Your Honor.
Mr. Salinas, did you review the court admonishments with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, Judge.
All right, you're charged with possession of a controlled substance, penalty group 1 less than 1 gram. If the state proves up the enhancement allegation, your range of punishment will be anywhere from 2 to 10 years in the prison and up to a $10,000 fine. If you have a plea with the state, the court does not have to follow your plea. If the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. You have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent. By entering this plea, you're giving up those rights. Did you intend to give up those rights and enter into a plea in this case?
Yes, ma'am.
Counsel, has your client been able to provide you with any defenses?
Yes, Your Honor.
Do you believe he has a rational as well as a factual understanding of the charges against him?
I believe he does, Judge.
Do you believe he's currently competent and was legally sane at the time of the offense?
Yes, ma'am, I do.
Mr. Salinas, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No, ma'am.
Anyone promised you anything other than the plea?
No, ma'am.
Are you satisfied with the way you've been represented?
Yes, ma'am.
If you're not a U.S. citizen, by entering this plea, you will be deported, denied naturalization, and re-entry. Did you understand?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it?
Yes, ma'am.
According to the plea, punishment is to be assessed at 2 years in the prison. There's an $800 fine. State recommends community supervision, and they're proceeding on count 2. And you're to agree that you've been previously convicted of 2 or more felonies for purposes of enhancement. Did you understand that to be your plea?
You said prison, ma'am, or probation?
I said that the plea bargaining agreement is 2 years in prison. There's an $800 fine. The state recommends community supervision. Did you understand that to be the plea?
Yes, ma'am.
Defense?
Yes, Your Honor.
State?
Yes, Judge.
Did you review the waiver of appeal paragraph with your attorney? Did you understand it and sign it in both places?
Yes, ma'am.
By signing that, you're waiving your right to appeal. The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, ma'am.
Counsel, any such motions?
No, Your Honor.
Outside the agreement, the state is recommending that your community supervision be for a term of 2 years. There be a top evaluation, 120 hours of community service restitution, the DOEP course, regular random UAs, and MRT. Did you understand those were recommendations from the state and the court does not have to follow those recommendations?
Yes, ma'am.
Then to count 2, how do you plead? Guilty, not guilty, or no contest?
No contest. No contest.
To enhancements, how do you plead? True or not true?
True. True.
State, any evidence?
Yes, Judge. State offers states exhibit 1 in all documents.
No objections, Your Honor.
All right, state, you may be excused. Did you review the waiver and stipulations with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, ma'am.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent? Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there'll be no live testimony? Did you understand?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments. Court has reviewed the same. Court will find there's sufficient evidence to find you guilty. The court will find you guilty. Are you proceeding with sentencing?
Yes, Your Honor. Waiving the PSI.
Anything you wish to say on behalf of your client?
Your Honor, as you can tell by the deal, I think this is a good opportunity for the client, for Mr. Salinas to do what he's supposed to do. He's motivated, and I would just ask you to follow the plea bargain.
All right, Mr. Salinas, do you have any children?
No, ma'am.
All right, who do you live by yourself or with someone else?
I would say my mom's.
All right, so how often have you been using?
I would say just occasionally.
Okay, so here's the thing. You need to be honest with me because in the report, it says that you were found passed out. And I can tell you all drugs are dangerous, but fentanyl is especially dangerous. So I need you to be honest with me so that I can get you the help that you need. I'm going to follow your agreement. I'm going to grant your application for probation, but I need to try to figure out what programs are best for you because otherwise only 1 or 2 things going to end up happening. Either you're going to end up in somebody's jail or prison for the rest of your life, or somebody may end up having to identify your body. And from reading this police report, you were close to that happening. So how often have you been using and what have you been using?
I mean, I just I just use it occasionally, man.
What does that mean? Occasionally.
Just maybe like once a week, twice a week.
Okay. So I'm going to give you conditions, and these conditions are to help you, okay? All right. So how far did you go in school?
I think 10th grade.
All right. This is what why did you drop out?
I started working.
Okay. This is what the court is going to do. The court is going to sentence you to 2 years in the prison, suspended and probated for 3 years. There's going to be regular reporting by Zoom or in person, regular random UAs in custody. I'm going to want an evaluation for felony drug court. Felony drug court will be able to see you first thing Monday because I'm going to sign that evaluation for today. I need you to be honest with them. They'll accept you in the program. They're going to help you with housing. They're going to help you with employment. They're going to help you, with your education. They'll be able to do all of that because you're going to need some extra help. If he's not accepted into felony drug court, I'm going to want a TAP evaluation, follow recommendations. Now, if you're accepted into felony drug court, which if you're honest with them, you will be, they will be in charge of your conditions of probation. There's going to be field visits 1 time per month until further notice. Proof of employment within 45 days of release, no employment as a home health care provider or minors. Are there any children that reside in the household with your mom?
No, ma'am.
All right. There's to be no residing in households with minors. There's to be no unsupervised contact with minors. There's going to be 300 hours of community service restitution. 100 of those hours will be deducted upon completion of a GED or some sort of trade school certification. The remaining hours, 1 hour will be deducted for every sober support meeting that is completed. There's an $800 fine. And that is going to be probated. So if you successfully complete probation, you won't have to pay that.
Okay.
Probation, is there anything else? Is there anything else you need from the court, Mr. Salinas, to be successful?
No, ma'am.
All right. Did you review the document entitled trial court certification? Oh, and I'm sorry. Yes. Did you review the document entitled trial court certification of defendant's rights to appeal with your attorney? Did you understand it and sign it electronically? Because it's a plea bargaining agreement, because I followed your plea bargaining agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what that is, you'll need to speak to an attorney. Do you understand?
Yes, ma'am.
All right. So if you need anything, let probation know, or you can come back and talk to me. I'll be here till December.
Okay, ma'am.
All right. I'm going to send you to breakout room number 3. And Greg, I sent you to 3 as well. Probation is going to zoom in to go over conditions with you.
Judge Greg has one more client that's here in the box.
All right. Who is it?
Kirk Lemus. Thank you, Judge.
Sure. Lemus.
And just let you know that's
You
first
wanna
of all I
talk
saw
about it?
him
Yes.
definitely because he threatened me when I was on the floor. Make sure like the whole story.
And Luis, I believe you can join breakout room number 3 if you know how to do that there. Good job.
Right.
And Your Honor, on this case, if you want me to
Yes.
start.
Yes.
This was from yesterday. So we're trying to work out a plea bargain. The state is going to contact the complainant, I believe, just to verify some information that's going to help us make a decision. So I just want to give her some time and appreciate her doing that.
All right. How much time do you need?
Whatever the court will allow. Judge State also gave an offer already. So.
All right. We'll do a plea deadline date. Greg, I know you teach and school ends for you when?
June 4th, Judge, but if if we can get, I mean, excuse me, I'll be done before June. So anytime after June 3rd, June 4th, I can come in. But obviously if we can work something out, then I will take time to get Turk taken care of.
All right, so what I'll do is I'll set it then in May. And then if you need to move it because of class, you can just place it on a different date. Just call the coordinator.
Thank you, Judge.
All right, Norma, if you can recall this in mid-May.
The 18th.
All right, so we'll be back on the 18th. If your attorney wants you brought back sooner, he'll let us know and we'll put you on the docket.
Thank you, ma'am.
All right, thank you. All right,
Judge, thank you again.
All right, thank you.
Thank you, ma'am.
Who's here on Caitlin Middell?
I am, Judge.
All righty. All right, if you'll come forward. Court is calling 2025 CR 013984 State versus Caitlin Middell. Could I have parties announced?
Florida, known to the state.
Charles Bunk for Miss Middell.
Are you Miss Middell? Counsel, have you received all discovery? Did you review it with your client?
Yes, Judge.
Court will find that the state is in compliance with discovery. Ms. Middell, did you review the application for deferred adjudication or community supervision with your attorney? Did you understand it and sign it?
Yes, ma'am.
Did you review the true bill of indictment with your attorney? Did you understand it?
Yes, ma'am.
Counsel, do you waive the reading of the indictment?
We do.
State, are you proceeding on the indictment as presented?
No, Your Honor, state will proceed on the lesser included offense of attempted burglary of a habitation.
Any objections?
None.
All right, did you review the court admonishments with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, ma'am.
All right, the state is proceeding on the lesser included offense of attempted burglary of a habitation. That's a third-degree felony. The range of punishment is anywhere from 2 to 10 years in the prison and up to a $10,000 fine. If you have a plea with the state, the court does not have to follow your plea. If the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you, and you will be allowed to withdraw your plea. You have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent. By entering this plea, you're giving up those rights. Did you intend to give those rights and enter into a plea in this case?
Yes, ma'am.
Did you understand if the court were to grant your application for deferred adjudication, if for any reason your deferred adjudication were revoked, the court could find you guilty and sentence you up to 10 years in the prison and up to a $10,000 fine?
Yes, ma'am.
Counsel, has your client been able to provide you with any defenses?
Yes, Judge.
Do you believe she has a rational as well as a factual understanding of the charges against her?
I do.
Do you believe she's currently competent and was legally sane at the time of the offense?
Yes.
Ms. Middell, has anyone threatened you, coerced you, placed you in fear to get you to enter this plea?
No, ma'am.
Anyone promise you anything other than the plea?
No, ma'am.
Are you satisfied with the way you've been represented?
Yes, ma'am.
If you're not a U.S. citizen, by entering this plea, you will be deported, denied naturalization, and re-entry. Did you understand?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived her right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it?
Yes, ma'am.
According to the plea, there's an $800 fine. State recommends deferred adjudication. There will be taken in consideration 2026 CR 004221 and 2026 AL 000772. And there's to be restitution to the complainant. Did you understand?
Yes, ma'am.
All right, off the record for a moment. Reynaldo Luna, I'm going to put you in the breakout room number 3. We're back on the record. Did your state in defense, do you agree that is the plea bargain agreement?
Yes, Judge.
Yes, Your Honor.
Did you review the waiver of appeal paragraph with your attorney? Did you understand it and sign it in both places? By signing that, you're waiving your right to appeal. The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand? Counsel, any such motions?
No, Judge.
Outside the agreement, the state is recommending that your community supervision be for a term of 2 years. There'll be a TAP evaluation, 100 hours community service restitution, no contact with the complainant, and the cognitive thinking course. Did you understand those were recommendations from the state and the court does not have to follow those recommendations? Then to the offense of attempted Burglary of a habitation, how do you plead? Guilty, not guilty, or no contest? State any evidence.
Yes, Your Honor, seat offer states exhibit 1 in all attachments.
Any objections?
No objection.
All right, state you may be excused. Did you review the waiver and stipulations with your attorney? Did you understand it and sign it in all the appropriate places? Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in the right to remain silent? Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports? But most importantly, there will be no live testimony. Did you understand?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments and review the same. All right, after reviewing states exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty. The court will defer finding of guilt as you've applied for deferred adjudication. Are you proceeding with sentencing?
Yes, Judge.
Anything you wish to say on behalf of your client?
We believe she's worthy of the plea bargain. We ask you to follow it.
All right, who are these other people you were with? What is their relationship to you?
I was with the ex-boyfriend.
All right, that's a bold move to someone's on vacation. Somebody breaks into the apartment, changes the locks and just lives there.
I didn't. I was at the wrong place. So.
Well, there's no such thing really as wrong place, wrong time. That's just something that people say, right? Do you have any children?
I lost mine.
I'm sorry to hear that. How far did you go in school?
I graduated. I have some college.
All right, so what are you planning on doing with the rest of your life?
I'm going for a hygienist. I'm a registered dental assistant.
All right, well, this is what I'm gonna tell you. Anytime you have any type of criminal case, whether it's deferred or not, anything that requires you to have a license, this is gonna appear in your background. I don't say you're not gonna get your license, but you just made your life more difficult. You understand?
Yes, ma'am.
All right, it's 3 years deferred adjudication, regular reporting by Zoom or in person, regular random UAs. There's gonna be a TAP evaluation out of custody. Follow recommendations. If TAP recommends inpatient treatment, we'll start with outpatient treatment. There's to be no contact with Julio Cesar Cadena. Street.
Yes, ma'am.
And how often have you been using? I'm sorry?
I don't use.
Well, they found a lot of things,
And
Xanax and everything,
yes, ma'am. I don't touch that. No more.
but you're with people who do.
I separated myself.
All right, there's going to be field visits 1 time per month until further notice. 200 hours community service restitution. I'm going to order MRT. 100 hours will be deducted for completion of MRT. The remaining hours will be deducted for every sober support meeting that is completed, 1 hour for every hour. Take in consideration 2026 CR 004221 and 2026 AL 00772. There's an $800 fine that will be probated. Probation, is there any proof of employment within 45 days of release? There's to be no employment as a home health care provider or with minors. There's to be no unsupervised contact with minors. And there's to be no residing in households with minors. Probation, is there anything else? Oh, well, I've already given her the MRT. Do you suggest cognitive thinking over the MRT? Okay, all right. Is there anything else that you need? All right, did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney?
Yes, ma'am.
Did you understand it and sign it?
Yes, ma'am.
Oh, and I'm sorry, there's to be no possession of firearms. All right, because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Do you understand?
Yes, ma'am.
Here on out, everything that you do, you need to ask yourself, is this something that could potentially result in me going to prison for 10 years? If the answer is yes, don't do it. If the answer is maybe, don't do it. You understand?
Yes, ma'am.
All right, good luck to you. Brenda Levenstein, who do you have?
Pablo Hall.
All right, thank you, Charles. What page is Pablo Hall on? Pablo Hall. He's not on page 2. What do you got? All right. Hello, how's it going? All right, what is happening with this case?
We have a plea bargain for 1244, 6 months in the Bear
I'm
County
waiting for the
Jail.
paper. I don't have the paperwork. Just give me a second.
Okay.
And then after this, I'm going to take up mental health court. We're going to go get it in the back. All right, if you'll just have a seat for me, they're going to grab your paperwork, then I'll take it up. All right, just give me a moment. They're going to grab the paperwork. A moment.
All right, friends, we're a few minutes behind her feed, so let's see if we can move forward.
Thank you. And counsel, are there any applications?
No.
Court is calling 2026 CR 004851. State versus Pablo Hall. Could I have parties announced for the record?
Lauren Espinoza for the state.
Brenda Levenstein for Mr. Hall.
All right, and Ms. Levenstein, you did not sign the discovery acknowledgement. Have you received all the discovery in this case?
I have.
And did you review it with your client?
Yes.
Court will find that the state is in compliance with discovery. Mr. Hall, did you review the true bill of indictment with your attorney? Did you understand it?
Yes, ma'am.
Counsel, do you waive the reading of the indictment?
Yes.
State, are you proceeding on the indictment as presented?
Yes, Judge.
All right, you need to sign that. Deputy, could you have him sign that, please?
I can come by and sign that later this morning.
Oh, you left
Thank
it.
Thank you.
Can't reach.
Thank you. Mr. Hall, did you review court admonishments with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, ma'am.
You're charged with possession of a controlled substance, penalty group 1 less than 1 gram. That's a state jail felony. Range of punishment is anywhere from 180 days up to 2 years in the state jail facility and up to a $10,000 fine. If you have a plea with the state, the court does not have to follow your plea. If the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you, and you will be allowed to withdraw your plea. You have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent. By entering this plea, you're giving up those rights. Did you intend to give up those rights and enter into a plea in this case? Counsel, has your client been able to provide you with any defenses?
Yes.
Do you believe he has a rational as well as a factual understanding of the charges against him?
I do.
Do you believe he's currently competent and was legally sane at the time of the offense?
Yes.
Mr. Hall, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No, ma'am.
Anyone promised you anything other than the plea?
No, ma'am.
Are you satisfied with the way you've been represented?
Yes, ma'am.
If you're not a U.S. citizen, by entering this plea, you will be deported, denied naturalization, and re-entry. Did you understand?
Yes.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it?
Yes, ma'am.
According to the plea, punishment is to be assessed at 6 months in the Bear County Jail under 1244. There's an $800 fine and no applications. Did you understand that to be the plea?
Yes, ma'am.
Defense?
Yes.
State?
Yes, Judge.
Did you review the waiver of appeal paragraph with your attorney? Did you understand it and sign it in both places?
Yes, ma'am.
By signing that, you're waiving your right to appeal. The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, ma'am.
Counsel, any such motions?
No.
Then to the offenses charged, how do you plead guilty, not guilty, or no contest?
Guilty.
State any evidence?
Yes, Your Honor, state over states exhibit 1 and all attachments.
No objection.
Did you state you may be excused? Did you review the waiver and stipulations with your attorney? Did you understand it? Did you sign it in all the appropriate places?
Yes, ma'am.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent? Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there will be no live testimony? Did you understand?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments. After reviewing the same, the court will find there is sufficient evidence to find you guilty, and the court will find you guilty. Are you proceeding with sentencing?
Yes, please.
Anything you wish to say on behalf of your client?
Just that it was a very small amount of controlled substance, and I believe this is a fitting punishment for that offense.
All right, the court will follow your agreement, sentence you to 6 months in the Bear County Jail under 1244. There's an $800 fine. Court, that time and money will run concurrently. Court will give you credit for any time served. Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it?
Yes, ma'am.
Because it's a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's motion to appeal. Because this is felony conviction, you're not allowed to own or possess any weapons, or if you have an attorney. All right, good luck to you.
All right, thank you.
You're welcome.
Thank you.
Can you tell me, are all the jurors here? Okay. Let me see. Has
Alrighty, I think she's about ready to get into the jury trial that she's been working on. Let's go back to Judge Elmore.
Please.
Your Honor, good morning again. For the record, Mark Burke, P54935, on behalf of the Attorney General's Office of the People.
All right.
Robert Champion appearing on behalf of Mr. Decatur, who is seated to my left, Your Honor.
All right. Also this morning is Ms. Laura Odell. She's the agent for the Michigan Department of Corrections. And we are on the opposite end almost of the last file. We were here back on March 3rd of 2025 for the entrance of a plea for failing to pay child support, in which there was a Killebrew agreement for up to 11-month delay, in which the defendant would be required to pay $234 a month on his arrears. And then the court conducted the sentencing on April 7th of 2025, placed him upon that delay. And according to the report that I have, he has had no issues while on supervision and apparently has complied. Any objections to proceeding and giving the defendant the benefit of the delay, Mr. Berg?
Your Honor, thank you very much. The number that I have that the defendant owes, the delayed sentence review hearing that I show was in March, I think March 13th of this year.
Yep.
It was adjourned to today's date to give the defendant a chance to pay the balance. His balance is incredibly low. It's $2,404.50 as of April 13th. I'm not sure if he's made any payments recently, but he's made great payments, and he's eligible for the attempt, but he's close enough for the disorderly. So I don't know if he wants additional time to try and get that balance paid down. I'd love to give him the time if the court wants to give him the time. If he can get that better benefit, I'm great with that. So I'll leave it at that.
So for Mr. Berge, and the courts, my client just made 3 days ago, another payment of $1,200. So he is unbelievably close in this situation.
All right,
So
so,
since that date and today, he's paid over $1,800.
all right, so, what's he have to be down? He had to pay it down to 0, right?
Correct.
Did he? I'm sorry. Did
Well-
he paid 12? He paid 1,200 3 days ago, and what was the other payment?
At the end of March, he made a $600 payment, but I believe that shows on the payment.
That shows.
It does. Yep.
Then he made a 12, the other one he just paid.
Correct. That was paid on the 16th, excuse me.
So we all know that on these failure to pay child support, the objective here is to get the child support paid. And it's less about punishments and things like that because Mr. Decatur is doing the right stuff. So I will do whatever the attorneys want, Mr. Burke. So what would you like to do? And by the way, I don't know if I can extend the delay any further because I'm supposed to lose jurisdiction. And I had extended last time because in February, I hadn't reached the year. Now I've surpassed the year. So I don't believe I can adjourn it again. I need to either have a resolution that I reduce it to the attempt or I reduce it to the disorderly. Now, if Mr. Burke, on behalf of the great state of Michigan, says, Judge, you know what? We're willing to allow him to take the disorderly, I'll do it. It's up to you, Mr. Burke.
Your Honor, if I may, thank you. Under 771.1, the delayed sentence statute, the court loses its jurisdiction after a year. However, the defendant can waive their jurisdictional regularity of the court going beyond the year. I believe the defendant did that back in March, and that's why it was adjourned to today's date.
Yeah.
And I have no problem with that continued adjournment. Quite frankly, Your Honor, I've seen delayed sentences run a year and a half, even longer. As long as the defendant's making payments and the defendant waives the jurisdictional regularity, I never have a problem with that. I'd rather give the defendant a little bit more time to get him to that better benefit, which is a disorderly, if he can pay it off in full. To me, that's a home run for everybody. It's a win-win for everybody.
I agree. I'm just trying to, I just want to make sure I interpret MCL 771.1 paragraph 2 appropriately. And it says the court may delay sentencing the defendant for not more than 1 year to give him the opportunity to prove to the court his eligibility for probation or other leniency with the ends of justice and the defendant's rehabilitation, blah, blah, blah. So keep reading. Yeah, see, I just don't think I've got I understand other courts will look the other way, but I already had a question about that today in another case, and I said, I can't look the other way.
Your Honor, I believe
sense.
there's case law that allows you to do that. And that's where it rises from. I don't have the case in front of me, but I believe there's case law. I mean, it's up to the defendant to waive that jurisdictional regularity, and if he does, then we can extend it for as long as the court will extend it.
I just don't think I've got that ability to do it, and I also am not the judge who's, when attorneys come in, well, the guy was charged with possession of meth. We're gonna let him plead to possession of toy. I just, that's the silly, don't really interpret the law. Well, other judges might do it, which, by the way, is a very common phrase. Well, the other judges do it. Having spent 24 years in the military and the Army, how many times I've been someplace around the world, well, that's how we've always done it. And then the lawyer goes, well, that's not the way the rules say, Lieutenant Colonel. So
What I can tell the court.
I would love it if we could reduce it to the disorderly today. But that's up to Mr. Burke. If he doesn't want to do it, it's got to get, how much is left now?
$1,200.
$1,200.
And
Anybody got $1,200? No, I'm just kidding.
what I can tell Mr. Burke in the court is that my client is going into his busiest season, okay? And he has been making regular payments. He's paid over $1,800 in the last month alone. Recognizing $1,200 is all that, I think in the interest of justice.
I understand. It's just, it's silly. Oh, wait, hold on. The clerk is giving me something. Hey, of that $1,200, is that that's not court assessments, is it?
No.
No. Okay. All right. All right, I'm sorry, I really want to. Mr. Gator's done a great job on this. I don't think I can, unless somebody can point to the statute or the case law and tell me I have the authority to go beyond the year, that I can. I can bring up and review the case after a year.
Your Honor, would you allow an adjournment for a week just so I can provide the court with some authority to extend the time?
No, because I'm on vacation next week. So here's what we're going to do. I will adjourn it for a couple weeks, have it reset. I'm not going to say it's 2 weeks because I don't know when that's going to be, to allow this question to be answered, whether or not I can exceed. I do know I do recall the case. I can't remember the case name, that I can still have jurisdiction as long as it gets scheduled. Tell you what, and I do kind of just wish I had that case right here. So I'll tell you what, the court will have it adjourned and reset as soon as it fits the court's docket, which, by the way, I'm not over here every day. So it's likely to be a couple of weeks. All right.
Thank you.
Thank you,
Your
guys.
Honor, thank you so much. Appreciate it.
All right, nobody mentioned that to anybody else.
Mr. Champion, thank you very much.
Thank you.
All right, so real quick, friends, hold up to the camera here. I just got delivered breakfast by Grandma TCF, which was very nice of her. She says it's for my sore knee, so I think it's that old adage, feed a knee, starve a cold. I think that's how that works. But I got some scrambled eggs with cheese and bacon and mushroom and a couple pieces of toast. So thank you, Mom. Appreciate that. We've reached that time, my friends, that beautiful time on a Friday where we indulge in our guilty pleasure. Appalachian justice, best served in a cold, dank basement where the screams of the dead can be heard in the background. The printer never stops running. Judge Capper often shouts off with your head. The walls are bleeding slightly. Everybody's panicked. Ladies and gentlemen, I give you Dungeon Court.
Judge, what there were co-defendants, and somehow there was a mix-up. Mr. Astor was going to prosecute the female, and Mr. Hill was going to prosecute Mr. Sippel. It got switched. Now it's back on track. Unfortunately, Mr. Hill is not here today, so we left it on as a pre-trial to get another date.
Okay, so you
just need a date, Judge.
Trial?
The trial, yes, trial. We've had multiple pre-trials. I don't think it's going to resolve itself,
So
short of a dismissal.
now, are they going to be tried at the same time or separately?
Assume the same thing. Now, I'm thinking, and I
So we
have
got
to
to
double.
coordinate Mr. Ashworth and
We
Mr.
do, but I think because my client at one point admitted ownership of the dogs, her
Correct.
case might have been dismissed because the dogs live in the same house, and he said they're my dogs, they're not hers. She has nothing to do with it. So I'd have to double check that though. He said we did that last time, so I don't
But
think.
it is Mr. Ashworth's case.
What's her name, remind me?
I mean, that's what's on the file.
Emily, his wife, is the one that Mr. Ashworth is prosecuting. Philip is prosecuting Mr. Sippel. At some point that got switched around, I don't know how, but I do know that we've had multiple pre-trials and we're just at an impasse, like I said, short of a dismissal, so we do need a bench trial date.
Okay, well,
I could do the 22nd or the 29th of May with my, I've got 6 jury trials in the next 3 weeks. If there's nothing set on those days trial-wise.
I've already set trials that day. Dates I've got open, 4th of May, 1st of May.
Let's see. Trials down in Ironton both.
Or the 11th of May.
Well, did you say the 1st of May?
1st of May.
I can do the 1st of May.
May 1st.
Yeah, I can do that. Then I get into a bunch of trials.
Excuse me. May 1st for trial.
May 1st, noon. Which was? Oh, I know, yeah. Put noon, you want to sit here all day anyway. Noon, May 1st. Thank you. All right, talk to you.
Thank you, Judge.
Thank you, Judge, appreciate that.
State of Ohio versus Melvin Christie. Case number CRV 26216. But you should be back in holding, Your Honor.
This is for arraignments. Melvin Christian. No, that's the 6 page. All right, sir, you're Melvin Christian? Yes, sir. I'm Judge Capper. This is what's called an arraignment hearing for you. So I'm going to go over what the charge is. You got a charge filed against you of menacing. It alleges that on April the 16th of this year, you not only caused Barbara Christian to believe you caused physical harm to her person or property. That's a 4th degree misdemeanor under Ohio law, carries a maximum penalty of 30 days in jail, $250 fine. That's the maximum. You have a right to remain silent. You don't have to say anything. You have a right to have an attorney, to have one appointed if you can't afford one. You have a right to bail, to make the state of Ohio approve this charge beyond a reasonable doubt. Do you understand those things?
Questions about this, I've never been in this situation.
Tell the judge they're working on it.
I never laid a hand on my wife.
Okay. Well, then I'm going to enter a not guilty plea.
We'll have to go back to jail.
Well, we're going to talk about that. Do you want a lawyer? Do you have the money to hire a lawyer?
Yes, I am.
Okay, so you want to hire your own lawyer?
Yes.
Okay. What's the state's position on bond for Mr. Christian?
Your Honor, Mr. Christian's daughter is here kind of on behalf of her mom, who is the alleged victim in this matter, and we would not oppose an OR bond to a facility. So TCC, I believe, is working on securing a bed for Mr. Christian, and then he also has VA benefits, so I know his daughter is looking into that as well.
Okay.
So once we have that figured out, once we have a bed secured, we would not oppose an OR bond. But the victim does request a temporary protection order in the meantime.
Well, do you need to assess him and talk with him, Mr. Wilson?
Yes, we should have an answer here shortly. His insurance did not cover through our company. We did not accept it, but we are looking into other options.
Okay, well, the VA has a lot of options in Huntington.
Well, one thing that my mother would like to see happen is to see him committed to the Chillicothe VA mental health, but we haven't made contact with them yet. this happened so quickly.
Has he been there before?
Yes, but it's been a couple years, it's 20 years ago or so. So it's been a while since he's been there, but we've been to the VA.
It's been 40 years ago.
Is it substance use related?
Yes.
Well, they have a brand new facility right across the river now, and I don't want to knock Chillicothe, but I've never had a good, let's just say this, they're not responsive. I try to get information from them,
Yeah.
and they do not respond.
We had this problem before when he was admitted to King's Daughters for 15 days. My mom filed temporary guardianship. We were within days of doing permanent guardianship, and my mom backed out.
Okay.
She's a long-term, I would consider her, battered woman syndrome. And so she's ready now to follow through. And I told her I want to take that pressure off her, and I want to take control over this.
Have you talked to anyone at the Spring Valley veterans? We've got a liaison there, Amanda Rayburn. I can give you
Yep.
the phone number.
I would appreciate any of that. We need
They're
help.
very helpful.
Yes, I mean, we want nothing but the best for him, but we're just not able to do it on our own anymore.
Does anybody from the prosecutor's office have that contact information? I know Mr. Hill does, but he's not here. Let's see.
My mom is very fearful, though. She doesn't want him to come back home at this point.
I understand.
Your Honor, I got $13,200. I got $50 at my house that my wife and I.
That he can't find. He pulled it out of his savings account and has been hiding it, rat pulling it around his house, and taking off doorknobs to try to keep my mom from getting it. It's very bad. It's very bad. He thinks he's hearing voices of men's voices, and they're not there. They're not there. He won't take his medicine correctly. He cannot. He needs to be in a medical facility. He needs help. He needs mental help. And it is substance abuse related, but it's also mental health.
Both?
Yes.
Okay,
He will not even take his Suboxone the right way.
Okay.
He crushes it up and snorts it and runs out, and they won't tell doctors.
No.
They lie, see,
That's
I'm
a
sorry,
lie.
I'm putting it all out there. My
That's a lie.
mom's ready to give depositions. She's just not able to stand in front of him. But she said she'll agree to a deposition and tell all the information. And we have documentation for the last 2 years of his behaviors. So and we know that he has advanced prostate cancer, and the doctors told him that people typically in his age or his state make it about 2 years, and we're coming close on that mark. And also he had brain cancer, and they told us that would come back in 10 years, and we're at 9 years. So we think there's something medically going on. He missed this.
Let's hold it right there.
He missed
We're not
this.
going to resolve this today, other than find a place for him to go.
Yes.
So I just sent Ms. Waldo the contact information for the representative from the VA. So let's bring them in on the mix, and I guess put him back in the holding cell, and we'll see what we can come up with, and I'm going to order that you stay away from your wife while this case is pending. So you're going to sign something that you agree to that. So that's called a temporary protection order. And what's her name? Barbara Christian. Okay, we'll deal with this later. Let's get some, and Mr. Wilson, do you still want to talk to him, or Mr. Wilson?
Yes, we'll let them know as soon as we can.
All right. We're going to have some people come back and talk. Sure.
Medical High versus Christopher Clark.
Raul, thank you for the $4.99. I very much appreciate that. So thank you very much.
Sir, are you Christopher Clark?
Yes, sir.
I'm Judge Jackman. This is an arraignment for you on an issue. It looks like there's a warrant for you out of Pike County, so that's Waverly. So what happens in Ohio on that, if there's a warrant for a person and it's in a county that doesn't touch the county that you're located in, contiguous, is a fancy word for it. So Pike County is not contiguous to Lawrence County, so you have a right to have a hearing to make sure I don't send you someplace you don't want to go. I can appoint a lawyer for you if you can't afford one. It'd only be the issue of whether there's a warrant there if I should order you to go to Pike County. You can waive that hearing. If you do that, I will give you a bond. If you can post it, I'll order you to go turn yourself in. If you can't post a bond, I'll order Pike County to come get you and take you up there for their hearing. And it was on a no operator's license charge is what they're saying.
Yes, sir.
So, how do you want to proceed? Do you want to have a hearing here? Do you want to waive a hearing? Do you want to try to postpone here? What do you want to do?
I would like to try to postpone here and turn myself in.
Okay. And you still live in Wayne?
No, sir, I moved, the warrant was over 11 or 15 years ago.
What's your current address?
It's 2701 First Highway, Lincoln, West Virginia.
Okay, so what I would do, I'll set a $2,000 bond. So what that means is if you got $2,000, you can post it with the clerk here. And then when you go turn yourself in Pike County, you get all $2,000 back. I will let you use a bail bondsman if you want to do that. Then you have to pay them the fee that you don't get back. Usually it's 10%. So $200 probably gets you out. Then if you don't show up there, the bail bondsman has to pay $2,000 to the court, and they don't want to do that.
Yeah.
So they'll come get you and take you to the jail
Yeah.
to make sure they don't have to pay the $2,000. So what do you want to do? You want to try?
Pay $2,000.
You want to pay the $2,000 here? Can you get that done this afternoon?
I can get it done, yes, she's here and go right now.
Okay, there's somebody here for Mr. Clark? Okay. The clerk's office to the right. We don't take checks. There's ATMs. You got cash, okay? Great. Go see the clerk, post it, and then what I'm going to do, so you're going to post it by noon today. So what I'm going to do, I'm going to give you a week to get out there and turn yourself in.
Yes, sir, thank you, sir.
So that's, what is that, the 24th? Yeah. Or get them, if you call them and get them to withdraw the warrant, that's all I got. As long as the warrant's there, then I have to honor it.
Yes, sir.
Once that warrant's withdrawn, for whatever reason, you made a deal with them or whatever, then we're good. But the warrant has to get withdrawn, either by you appearing or them agreeing to withdraw the warrant.
Okay. Yes, sir.
So what I want you to do, because we have court at 10 o'clock, next Friday I'll have court. And I'm going to tell the prosecutor, if we don't have some documentary proof that the warrant was wrong, check and make sure the warrant's wrong. If it's not, then we're going to have a problem. So I want you to get up there before then. So I'm giving you until 8 a.m. That's what I'm writing down. Turn yourself in before 8 a.m. on the 24th.
Yes, sir, no problem.
Or if you can't do that, something happens, you can't get up there, providentially hindered. Means God stopped you from going up there. You got to show up here at 10 a.m. and explain to me why you couldn't get to Pike County and get this taken care of.
Yes, sir.
If you just don't, you blow it off and don't show up, then you're going to lose the $2,000.
Yes, sir.
Okay. So here's what I've written down. $2,000 bond to turn yourself in to Pike County before April 24th at 8 a.m. or appear in this court on April 24th at 10 a.m. to explain why you did not appear.
Yes, sir.
You understand then?
Yes, sir.
Okay, I've signed it. You'll need, there's a place for you to sign. So, and if your person goes and posts a bond, they'll send paperwork down to the jail to release you, so she can come down there after court's over and pick you up here shortly.
Yes, sir.
Okay, any questions, sir?
No, sir.
Okay, that's all. So I'm putting it on our docket for the 24th as a pretrial.
State of Ohio versus Raymond Jackson, case number CRA 25352.
Sir, you're Raymond Jackson.
Yes, sir.
Mr. Jackson, I'm Judge Capper. This is what we call an arraignment hearing, the purpose of which is to tell you what charges you have, what the possible penalties are for those. Yeah, I have to tell you your rights first. You have a right to remain silent. You don't have to say anything, but we're on the record here, and it's not privileged what you say. So if you say something and admit something about your case, it could be used against you. You talk to a lawyer, when you're talking to a lawyer, that's all privilege. We can't use that against you. So less said the better about the facts. It's not a trial today. I'm not going to throw the case out because you tell me some version of what he's been at. You have a right to have an attorney, to have one appointed if you can't afford one. You have a right to have bail and to make the state prove this charge beyond a reasonable doubt. You understand those things?
Yes, sir.
Okay, so now I'm going to go over the charge with you. It's possession of drugs. The state's alleging that at Fayette Township on May 22nd, so this is an older case, May 22nd of 2025, so almost a year ago.
Yes, sir.
You knowingly obtained, possessed, or used methamphetamine, and that's a Schedule II substance. Carries a maximum penalty of a year in jail, $2,500 fine. You understand the charge?
Yeah, I did understand.
Okay, and do you have the money to hire a lawyer?
Yes, sir.
Do you have a job?
No, I'm with this.
Okay. Mr. Smith, I'll point you. Okay, Mr. Smith is going to be your lawyer. State's position on bond for Mr. Jackson, and I've got an address for you from Beaver, Ohio. Is that where you live?
Yes, sir. Yes, my parents' address. I do stay there, but I also stay with a friend too.
Here?
No, I was going to a friend's house from my parents. Is how when I got pulled over.
Okay.
And they found something. I noticed.
Ms. Waldo, what's the state's position on bond for Mr. Jackson?
Your Honor, we would not oppose an OR bond if Mr. Jackson was agreeable to be assessed for treatment.
He has Ohio Medicare, Medicaid.
And he's agreeable to go to assessment for treatment?
Yes, he is, Judge.
Do you have Medicare and Medicaid both?
Yeah, I have to carry it.
I know some people have both.
Yeah, I have to disability.
Right, once you get disability, you have Medicare. So we may be looking at ODP. I don't know, who can, does anybody else want to take Medicare? Okay. All right, I forgot which agency you moved to.
UFR, United Over Recovery.
Okay, we want to talk to him, and then we'll decide, come back after we've done it. And we'll decide the details. You're gonna come back, or we'll let you talk to somebody to get an assessment, we'll come back in and sign bonds, that sort of thing. So, today, that'll be today.
State of Ohio versus Emory Markle Jr., case number CRV 2938 A and Z, CRV 222694 A and Z.
You're Emory Markle?
Yes, sir.
Junior?
Yes, sir.
Mr. Markle, I've got it down from the record that you missed a review hearing on March 27th of this year and that looks like these are traffic things. No operator's license and a theft offense. Do you admit or deny you missed your review?
Yes, sir.
Do you have an explanation?
No, sir, I don't.
Actually, you had a bond up from, that you posted, I don't know how we missed that. February the 10th, 2026.
I don't know what that was. I was around and they brought me in here. I got picked up on these warrants and they brought me in here.
Yeah.
I thought it was.
You posted a bond. I did an order
And then I came
that you were sentenced to 16 days in jail for failing to appear, but you could post a bond to be released and show up for review on February 23rd, which I think you did show up. You showed up on February, well, maybe you didn't. I've got bench warrant for failure to appear on that day. And then you showed up a few days later and got arraigned. But then I said the next hearing for March 27th, you didn't show up.
I got a review hearings in March County down in March too.
Well, how'd you get picked up this time?
Oh, just brought me up.
Oh, you were a passenger? Were they speeding or what were they doing?
No, I think that iron thing.
Okay. How long you been in jail?
A couple days.
Well, I don't know. It doesn't look like you're ever going to do this stuff. You were ordered to pay a fine and do some community service, and you did pay a little bit on it. You paid $170 on one case.
Yes, sir.
I mean, let's see. Do you want to just lay it out in jail, or do you want to try to do?
I want to try to do this. And I actually was at the community cleanup up here.
Oh, were you?
Yeah.
When?
Saturday, like week ago.
Which one?
Maybe a week and a half ago at the Burlington Fire Department.
Was you doing it for hiring?
I just heard that you could go up there, and I was up there. I mean.
Did you sign in with anybody?
I don't think I did.
Yeah, because we would give you credit if you came and signed in and thought you were there to do community service, because some people just show up because they want to help out.
Right.
They don't have to.
I didn't know, that's what I did, I just showed up.
Yeah.
I'm just trying to do the right thing, I'm just trying to.
Well, these court days, when you miss a court day, that's.
Yes, sir. Yes,
bad stuff happens, because you're going to get a warrant for not showing up. So you need to be a little more nervous.
Yes, sir.
As a lawyer, I'm really nervous if I'm late for a hearing.
Yes, sir.
Especially when, back in the day, when I was down inside of the county, because those judges were Judge Burton and Litton. They put lawyers in jail for being late. Not for missing a hearing, for being late for a hearing. They would put lawyers in jail.
The ones we got down are a little bit easier.
Yeah. Well, it's like everything. Everything's easier now these days. Back in the old days, that's what old people say. It was always tougher in the old days. So. But it was true, because those two guys, they were tough on lawyers. Okay, well, I'll let you try to do this again, because the jail is not gonna move. The jail's gonna be there, and you're gonna get a warrant if you don't do it, and if you don't show up.
Yes, sir. Yes, sir.
So let me tell you what I'm showing you still have left. You owe 30 hours community service on case number 2938, $465. And that was a theft offense conviction. The other one was a traffic charge. You owe 18 hours of community service, so that's 3 days, $630 on it, and that was a driving under suspension. Okay, and you want to do it? You don't want me just convert it to jail now? I wouldn't either, because I've visited that jail, but I wouldn't want to spend the night there. But I would act like I was scared of going back there and make sure I got to my places I'm supposed to go, my hearings, and be nervous about it if I thought I'd missed something. Do you have a smartphone?
I have no phone.
You don't have a phone? You're the second person.
I have no phone.
I've been asking that question here for quite a while. You're the second person that's ever told me. But everybody has a smartphone, I was just saying. You can check your case by going on your smartphone to the court's website, pull up your name, it'll tell you when your hearing dates are. And the ladies here love to answer the telephone.
Oh, yeah.
We actually have telephones here. You can't text us and we'll text you back, like my kids. My kids won't answer the phone either. But they won't answer when I text them. But you have to call and ask the question, when am I supposed to be there? What am I supposed to do? They love to look that up and tell you. You can do it yourself if you get a smartphone like everybody else. You don't even have to call them. Okay, I'm going to give you another hearing date. Are you going to remember? Let's write it down and give it to them.
Yes, sir.
You'll probably lose the paper, but how could you get it? The information if you forget. How can you get the information if you forget?
Oh, I'm not going to lose it.
All court. Somebody's got a smartphone that you know, so you can have them look it up. There's no excuse for not coming to your hearings. And it doesn't matter if you got it, unless being in the hospital, now that's a good excuse, but forgetting or losing your paper, that's not a good reason. So I'm going to set it for the 26th of May, and that's a Tuesday, not a Monday. May 26th is your next review hearing date.
Okay.
And if you don't show up, what are you going to get?
A warrant.
A warrant. Exactly. So act like that scares you. Do what you're supposed to do. Okay, that's all.
Thank you, sir.
You're welcome.
Alrighty, friends. Well, I see in the comments that somebody believes that today's court cases were boring. They may not have been the most exciting that we've had all week, but interestingly enough, looking at the stats right now, today's viewership was double the next best day that we had all week. So to each their own, I guess. Regardless, I hope y'all had fun. I did, so much so that we'll be back on Monday, 9 a.m. Eastern, 6 a.m. Pacific, a half an hour earlier if you are a channel member. Go on about the rest of your day and the weekend. Enjoy yourselves. Have fun. I look forward to seeing y'all on Monday. We'll be posting some stuff throughout the weekend too, so be sure to check that out. Take care. God bless.